Yes.
Good morning. Welcome to the July 10th, 2025 meeting of the Charter Revision Board.
July 9th.
No,
What?
Mr. Chair, it's the ninth.
Right, Wednesday, and I'm sorry, tomorrow's the 10th. Thank you. And I'm going to call the meeting to order, and we could stand for the Pledge of Allegiance. Pledge of Allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, and the clerk could please take the roll.
Mr. Chair. Michael Albetta.
Here.
Nadine Hankerson.
Here.
Mary Peliquin.
Here.
Ms. Norris Weeks.
Here.
And Chair Weiss.
Yes.
You do have a quorum, sir.
Just a couple of notes. First of all, I know these are 2 long days, and I know that several people have different things happening. So if you just let me know, we'll try to accommodate. If you have to make a phone call or something like we could take a break. Some people have some medical issues with family and stuff like that. So we'll do whatever we can to just try to do our work, but try to accommodate everybody if we can. And Bernadette, if you don't mind just taking a minute to brag on yourself a little bit. Bernadette is a very well-known municipal and other attorney, and just maybe tell the group a little bit about you.
Thank you, Mr. Chair. I'm Bernadette Norris Weeks, and it's a pleasure to be here and look forward to working with all of you. As Mr. Weiss indicated, I represent governmental entities throughout the South Florida area. My firm does, and I've had the pleasure of working with some of you on in some other capacities, and so I look forward to this experience together as we try to make our city the best city that it can be.
That's great. I would say personally that I'm so happy that you're here, to have another municipal attorney here with the kind of background that you have. I really am. I begged the commissioner that appointed you. I didn't tell him who to appoint, but I said, please appoint somebody with a really good municipal background, and there we are. So that's terrific. We're going to use first names, try to be very informal. Unless things get totally out of hand with Anthony, you don't need to raise your hand, just sort of talk. Michael gets a lot of hand from time to time. A little crazy from time to time.
Nice.
Okay.
Thank you.
Paul, did anybody else have anything good in the order, Anthony?
If I could just make the announcement that I told you about this morning.
Sure.
So there are items on your agenda that we would like to move to a later agenda. If you look on the first page, subsection 2, subsection D, section 4.07, assistance to the city manager, and then under B2A, section 4.06.
Where are you? I'm sorry.
This is the first page of the agenda.
Yes.
So at the bottom,
Yes.
A2D,
Got it.
section 4.07, and B2A, section 4.06. These are assistance to the city manager and acting city manager upon resignation or during the absence or disability of the city manager. City manager's office would like to be able to converse with the Charter Revision Board on those two, so they're asking that these be moved to another agenda.
If I executive fiat, we're gonna move those to a later agenda.
Okay?
And, so 4.07 and 4.06, right?
Yes. And then on page 2, under new business, towards the bottom of the page, B1, B2, and B3, these are sections 601, 604, and 605. Unfortunately, staff from HR who made these requests can't be here
Okay.
to talk about them, so they'd like to move those as well. Other than that, everything else.
So that's for both the days?
That's for both the days.
Okay, so we'll move those to the agenda after these 2 days?
Yeah.
Great.
All right, cool.
Have you had an opportunity to review the minutes of the July 5th meeting? If you have, I take a motion to approve them.
I second.
All in favor?
Aye.
All
I'm sorry, who moved to approve?
Bernadette.
very nice.
Thank you.
Is everybody okay with first names? Yeah?
Oh, yeah.
Alright, is that okay with you? What? No, I wanna be.
The joke. I said, is that okay, Richard?
Oh, I got it. It's early. It's okay. So, under old business, first I'd like to thank both the city attorney's office and the manager's office for helping us put all this stuff together for the agenda. Yes.
Chair, just wanted to acknowledge Tiffany Bain. Tiffany, if you could introduce yourself.
Oh, good morning, Chairman Weiss, and good morning, Board. I am Tiffany K. Bain. I'm the Director of the Strategic Initiatives and Administration. I might have flipped it. I'm pretty much the manager's chief of staff.
Oh.
Just wanted to introduce myself. So
Great.
a few of us from the city manager's office may be coming in over the next few days just
Okay,
to
well, that's great. We're happy to have you. And feel free to chime in. Jim, Kincannon, is that his name?
Yeah, Jim Concannon, yeah.
Kincannon, he sent an email apologizing for not being here because he's been a citizen person that's always attended, so. But it was nice, he sent an email apologizing for not attending.
He's got something else,
Sort of
stuff
thing,
he's
so,
gotta do.
okay. All right, okay, so under old business, the first thing we were doing was going through a conflict chart that was prepared by the city attorney's office. And these are the sections that we're gonna discuss. So Paul, if you could sort of take over and start with A1, 1A.
Sure. Good morning, everyone, and the conflict chart that I'm gonna discuss is exhibit A1. And let me just explain, a couple of years ago, the Charter Revision Board had asked me to create a list of sections that I thought conflicted with existing. So I listed them with the current charter section, the conflicting authority, and a proposed solution. If you look at the chart, you see the three columns. Now, some of these have become moot, as I'll explain, primarily because some of them have been dealt with in other discussions, and the board has approved the sections in other versions of the section, let's put it that way. So some of these are moot, but I'll go through in any of them.
If they're moved, don't go through them.
But unless,
I would,
You wanna hear it?
I would like to hear
that's
it,
what
okay, so that I
for
can
the new
That's
kind of
fine,
adjust my
no problem.
brain.
Yeah, I can explain a little. So I'll start with the ones that the board, the sections that are on the list,
Okay.
on which this current board
Yeah.
has taken action, okay?
Yeah, just for Bernadette's information, what happened, we did a whole sort of charter review process with a different board. And then I'm the only survivor of the process. We did tons of work. And then this new board was approved, was appointed. And I didn't feel like it was appropriate or nice to just basically say, okay, that's what the old board did. And so we basically started from scratch to give the new board the opportunity to look at what the old board did, say, happy with it, not happy with it, and so we're starting to start from scratch. Okay, good.
Okay, so I'll start with 3.04, which it looks like I'm not going in order, but this is in order, these are sections on which the current board is taking action. Okay, so I'll start with 3.04. And that is judge of elections and qualifications of members. This board's recommendation is to repeal the section because pursuant to the special act of the legislature governing municipal elections in Broward County, the county canvassing board canvasses all municipal elections in Broward County, and there are judicial remedies for the potential challenges described in this current section. So currently, the city commission is the judge, the way it's written now, the city commission is the judge of municipal elections and referenda and of the qualifications of its members, subject to review by the courts. And it provides that the city commission canvasses the results, and that's archaic with the special act of the legislature. And at the time of canvassing, any registered elector may file an affidavit showing that a candidate has violated provisions of the charter or is otherwise unqualified to hold office. So your recommendation was to repeal this section. So I'm just explaining that. I don't think you need to take any action by way of.
No, but I would like to give Bernadette an
Yeah.
opportunity to, if you have
No, I
something,
totally understand.
you get it, okay.
Yeah, the only thing I guess I'm wondering, and this will probably come up with some other place, normally the city commission is they do determine, qualifications of its members. And so I'm assuming that comes somewhere else, but this deals with, I understand the rationale behind repealing this part or this provision.
We did have a very long discussion at prior as to, you know, what that, I know that provision is in sort of every charter, which is there, but it's sort of, there's no procedure for it, and it always becomes like very, very uncomfortable. And so that's why this section was eliminated. When, you know, I mean, during the last election, you know, there was a whole issue of residency and all of that, and ultimately, it sort of ends up in the courts anyway. So our thought was, take it away from the commission and leave it in the courts, and let people sue. But
Yeah, like a lot of times, and I don't know if this appears somewhere else, and forgive me, I haven't done as much as I would have liked to have done prior
we're
to
very
this,
short,
prior to this
we were
meeting.
happy to have you.
But a lot of times, like if a commissioner misses 4 consecutive meetings, you know, in a fiscal year or whatever the case may be, generally the commission can address that somehow. And so is there some other provision for something like that if you had someone who just couldn't be available or didn't want to be available or whatever for,
I can't point to it at the moment, I believe there is something that addresses that.
okay.
Let's make a note of it. This section just deals with municipal elections
Yeah, I
or
understand,
referendums.
right. When you said qualifications of it, just mentioned that, just brought up that triggered that thought, but thanks.
Okay. So with that footnote, that we're gonna look for it later on.
Yeah.
This has already been approved unless you have something else to, so it's just, we don't need to reapprove it, we've already done it. Because we make very slow progress when we approve something, it's a big thing. Okay,
Don't
good.
undo that.
So what?
Don't undo anything we approved.
No, she can, okay, good, Paul.
Thank you. The next one that you have, that you have approved is 3.15, which is initiative referendum petition for proposed ordinance. So the board has recommended restating section 3.15 almost in its entirety related to the initiative and referendum process. In the proposal that the board has approved, initiative refers to the electors proposing ordinances to the city commission for adoption, and the term referendum refers to the electors requiring the city commission to reconsider any previously adopted ordinance, and if the city commission fails to repeal an ordinance, to approve or reject it at a city election. The proposal excludes budgeting, salaries, taxes, and zoning from the initiative and referendum processes. I can go through the recommended procedure if you'd like. Go through it a little.
Well, we've already
This
approved
is- yeah,
this,
this is
so
all
I'm
approved.
gonna ask Bernadette whether you would like him to sort of go through, or you're
Not
okay?
necessary,
If you're okay with it?
Yes, thank you.
Alright, so let's move on.
Okay, as a result of approving 3.15, 3.17, and 3.20 became moot. Okay, so they're listed there, but that's the reason.
Okay.
Now, these next sections are for discussion. They have not been approved yet by this board. And I will start with 10.03.
Okay, you're on page
That's the first page of Exhibit
first
A1.
one, right? 10 point,
At the very
is the first one on the chart.
no, but where is the language? What
And the language is,
It's on 111, exhibit A-2.
Yeah, I was looking for the redraft of 111, got it.
yeah, and that's one that's recommended for deletion, for
So why don't you go through your correction?
Okay, so section 10.03 requires 2 newspaper publications for all public hearings. Once, at least 12 days before the date of the public hearing, and the second publication 7 days after the first publication. We're not aware of any legal requirement for such publications, and the government in the Sunshine Law provides for reasonable notice of public meetings. My suspicion, although I haven't confirmed it, my suspicion is that 10.03 predates the Sunshine Law, possibly. So there are specific publication requirements in 10.03 that we don't think are necessary. And one anomaly that this requirement creates is that on the city commission agenda, ordinances are in a separate section, separate from public hearings. Whereas by statute, the public can be heard, in quotes, be heard at the ordinance reading, suggesting that consideration of ordinances is public hearing. So, so the reason that they are not in the public hearings section of the ordinance is because, of the agenda, is because of the publication requirements in the charter. So ordinances have to be, by law, ordinances have to be published once, at least 10 days before adoption. So therefore, it was my recommendation that 10.03 is not necessary.
By state law, they have to be published, right? By
Yes,
state law.
by state law.
And now the cities have an option of even putting it on the county's website if they chose, which I doubt would happen, but that is an option.
So basically, what this does, Paul, is you're saying, whatever is required by state law, we don't need to have our own section here, because it just becomes cumbersome, right?
The state law governs notice of public meetings. So this is something that the city has for publication of what the city calls public hearings. So anything that's called a public hearing has to have these two advertisements in the newspaper. Whereas the law only requires publication of, requires notice of public meetings, but as to ordinances, it requires publication at least 10 days before adoption.
Plus, I also think any reference in the charter to newspapers is at some point gonna be, probably half the people in this table, you certainly don't get a physical newspaper anymore. So I'm fine, does anybody have any comments about?
Although,
Oh, you do?
Oh,
Wait, you
I got mine on
get the hard, really?
Yeah.
You could be my friend, because I need a newspaper for my workshop project.
I have a lot,
Since I don't
I
have
can bring
any-
my bag
Since I
tomorrow.
don't get any newspaper anymore,
Our neighbor does, we get his all the time.
Yeah.
Take his
I
when he's
need
done.
it for projects. So,
I've asked around, and maybe Anthony can add something, but I've asked around even for land use, I'm not aware of any general requirement that public hearings that the notice be published in this way, except for what our city requires, our charter requires. Yeah. Now, one of the things I would also suggest, if you agree with this, is, and entirely up to you, whether you want to make a recommendation to reorder city commission's agenda and put ordinances under public hearings. So that if this section goes away, you can have ordinances under public hearings.
And that's what I think most cities do.
yes, they do.
So actually, we did a little survey. Okay.
Well, I think that's a terrific idea.
I think it makes sense.
Why don't we do a footnote? When I did this for Broward, were you in Broward County with me?
Charter review?
Yeah.
I was.
Twice, right? If we did footnotes, and we said, it's not within, we don't want to include it in the charter, but we would suggest that this be done. So I think there should be maybe a footnote suggesting to the city commission that maybe they want to consider, use about 3, maybe consider, so we're not telling what let's do a footnote, saying maybe they want to consider including ordinances just under, these things like that.
And let me just share with you, if you don't mind, let me just share with you the language from the statute, just a sentence, which is prompting my suggestion. The notice shall advise that interested parties may appear at the meeting and be heard with respect to the proposed ordinance. That's why I suggest that that's a public hearing. Correct.
Certainly.
Okay, so do I have a motion to, yes,
Just a comment, this would lead maybe a lot of backlash from the public sitting in the meeting,
Yeah.
that they weren't informed.
Yeah.
We did our due diligence.
okay. So with the footnote, that'll be carefully drafted so we don't offend anybody. Do we have a motion to eliminate 10.03? Michael moved.
I'll second.
All in favor?
Aye.
Great. And you have a note on the footnote. Okay, I got it. Okay,
Mr. Chair, do you want a roll call?
all in favor, that was. All opposed? We don't need to do roll.
Okay.
Somebody has a squawk, they look. Alright, so, alright, that's 10.3, go ahead, Paul.
The next one I have is 3.12 for discussion. And that is on the first page of exhibit A1.
Right.
On the chart, there you go. And the section is 3 pages over. Okay, so section 3.12 provides for the calling of special meetings of the city commission upon at least 6 hours notice. There really should be more notice, in my opinion. The government in the Sunshine Law requires reasonable notice of public meetings. The Broward County Charter requires at least 48 hours website posting of any required notices, agendas, and available backup materials, and that applies to municipalities. If there is an emergency and it is not possible to post the meeting notice at least 48 hours prior to the meeting, then the meeting notice must be posted at the earliest practical time. This is for the Broward County Charter. The Florida Attorney General's Office recommends that special meetings should have no less than 24, preferably at least 72 hours reasonable notice to the public. The Attorney General recommends that emergency sessions, quoting here, emergency sessions should be afforded the most appropriate and effective notice under the circumstances. So it is my recommendation that section 3.12 be changed to provide for at least 72 hours notice, or in the event of an emergency as determined by the mayor or the city manager, in consultation with the city attorney, at least 24 hours notice. Now, that section could also be read as what notice commissioners get as opposed to what the public gets. So it's excuse me, if commissioners get at least 6 hours notice, but the meeting is until 24 hours or 48 hours notice, that would probably work as well, but I think there may be some confusion there because I think it's the same notice that the commissioners get and what the public gets is what I think it's intended to do. And again, this probably predates the Sunshine Law, but I can't tell you that for sure.
Okay, so just to get an idea, are people generally comfortable with 72 hours notice,
I am.
except in an emergency? Okay, so we have the time limit, okay. And then the question is, do we feel like it's appropriate that for an emergency, it's to be determined by the mayor or the city manager and in consultation, I don't know what that means, in consultation with the city attorney?
They normally don't care about us,
They don't
but-
care about us anyway. But I think it's sort of a check and balance built in with the city attorney. Are we okay with that? Okay. So then the question is, should we specify here the type of notice? Because the rest of the paragraph deals with that.
Well, I think it contemplates public notice that you would normally post, whether it's on your website and, it's not newspaper notice, obviously. So, the notice that the clerk would normally, and maybe that's a question for the clerk, how does she normally post the notices? Does it go on the front door? Does it go on the website? Does it go on, at the parks? I don't know.
David,
Sorry, which notices are you referring to?
just like we were gonna have a meeting on 72 hours notice,
Okay,
how would you post
so
it?
normally it would be sent out to them, but I'm not via the front door anymore. It's by email and just everyone copied on it. Or they're sent to them individually notifying that there's going to be a special meeting.
Yeah, and I'm talking about the public, like how does the public get the notice?
As soon as it's called, we would add it to the Legistar calendar where we put all of the notices on. We would put it on the event calendar, and strategic communications would most likely get involved to send out a notice that there's an upcoming special meeting, what it's about.
Can I ask an obvious question? You wouldn't hold a meeting on 6 hours notice, would you? I mean,
We've agreed on 72 hours notice.
because the way this is written, currently it's 6 hours.
We've
It'll be
agreed on
tough, but I guess it could have.
It's probably old language.
So just, it would be sent out just
This-
like the regular meeting,
this
that,
Right.
yeah, okay.
This basically says 72 hours notice or an emergency, 24 hours notice. We didn't talk about, is everybody okay with the emergency on 24 hours notice?
If I may add,
Emergency issue.
I included the city attorney there just to, I would say as a check on whether
We
there
like
is
giving
an
power to the
emergency.
city. Let me ask you a question. Would there be a circumstance where a meeting would have to be called on less than 24 hours notice?
Certainly like the flood.
Like a flood
The
or a
flood
terrible,
would be a perfect
and are we like
But that would be an emergency, right?
But it says that, in the event of emergency is determined to become at least 24 hours notice. So this is 72 hours notice, but for an emergency, 24 hours notice. I have some concerns
It'd be too late.
that, whatever.
Maybe 12 hours.
It'd be too late.
No, 12
I mean,
hours.
emergency is an emergency, I mean, like, I just think of the flood.
Take for instance, excuse me, Mr. Chair, Richard, what just happened in Texas, the mayor's getting backlash there because he didn't call an emergency meeting or warning or anything else that's going on there.
I honestly think that if something needs to be done, that we should make it easy, we should try to facilitate that. And then if there's something terrible, maybe we could say on no less than 6 hours notice, on no less than.
And if that's the type of
That's what I mean.
event that you're referring to really, where you do give, something no less than whatever it is, it should probably state what type of emergency condition would exist under those circumstances, like in the case of,
Right, it says the call notice shall state the general purpose of the meeting.
right, so but my point is, if you're contemplating less than 24 hours notice, maybe you want to state, because I think the public does have a right to know about meetings and should be aware of what's going on.
Could it be like
And you wouldn't
a
want-
life-threatening?
Yeah, or something, and there's language in other
I think
charters, but
emergency is pretty
yes.
broad.
yeah, emergency's broad, so you don't want, to have we don't have any commissioners like that now, but you don't wanna have a rogue, manager, mayor, and someone's just calling an emergency meeting and it's really not an emergency, and, those issues come up as well, so.
Mr. Chairman, there's a little disconnect in the materials because the Attorney General calls it special meetings and says should have no less than 24 and preferably at least 72. I didn't see where the Attorney General, maybe we could research a little further, I didn't see where the Attorney General addressed emergency meetings, but the county charter does. And it says, the meeting notice must be posted at the earliest practical time. If there's an emergency and it's not possible to post at least 48 hours in, then post it at the earliest practical time. So the county charter contemplates emergencies more than what I found with the Attorney General.
What are your thoughts
And then-
about something like language like that, the earliest practical time for an emergency? And maybe add stating the nature of the emergency in the notice.
Well, I'll tell you where that came from. That was actually language that I proposed because we had someone who was very upset on that Charter Review Commission about about the cities just calling meetings, and he felt he does some governmental work, although he's not a governmental attorney, but he had some concerns, and people thought it was very practical to go ahead and allow there to be a certain standard for the notice, like 48 hours. And then my language was working in local government, understanding that sometimes you don't always have the information and you don't always, you're not always able to post with everything that's available. So that's where that earliest practical time came from. But
Do you remember in the early 2000s, the run on the State Board of Administration funds that local governments had deposited, and there was a run on the fund, and local governments were scrambling around to have meetings as fast as they could because they needed to get their money out. That was a situation where there was.
yeah. So it wasn't so much intended for an emergency situation, the language that you're talking about in the county. Although I do think that we probably, and maybe the commission feels differently and they'll share with us what their thoughts are, but I do think that if you make the time less than 24 hours, that you should state what those emergency conditions should be in order to be able to call it an emergency meeting. Because how does that differ from a
I
special
was
meeting?
thinking, I don't think there's any different, I mean, and I think these are like small emergency meetings, I don't think there's a special meeting. I mean, normally I think of a special meeting as something that's not in the regular sequence.
Right.
But maybe we should say if they can't do 72 hours, then they can do it on less, specifying the nature of the emergency and providing as much as possible. That's what you're saying, right?
Yeah, well, actually, I'm stating that there should be a different standard for an emergency meeting as opposed to a special meeting that requires 24 hours,
Oh, I see what
72
you're
hours.
saying, you're saying like
Should be-
3 different categories?
Yeah, there should be a different standard for the emergency meeting. The emergency meeting should not require, if you're gonna do something less than 24 hours notice or, or 24 hours notice even, you should have some standard that requires, that allows you to do that where the public doesn't have, because I don't think 24 hours is really adequate notice unless there is something catastrophic that is going on. And that's just my opinion, so.
I agree with you. I agree with you. Okay, so what are you suggesting exactly?
Well, if we were looking at the language,
Yes.
it would be, in the event of an emergency as determined by the mayor, the city manager, in consultation with the city attorney, at least 24 hours notice, and then I'm gonna pause for a second with each member of the city, all of that.
Right,
But at least 24 hours notice, in the event of X, Y, Z, whatever, life, save, health, matters that are of, importance to the city or something. So that because I actually have in one city that we represent where there were, this has come up, and the folks would actually try to have meetings, at least the majority of the commission, they were trying to have meetings when there weren't really emergency situations, but they were calling them emergency meetings, and they weren't really emergency situations. And so they didn't meet those standards, which allowed the city manager to not schedule it because it didn't meet the standards.
they're making emergencies that weren't
That weren't emergencies.
Okay, so we have 3 categories of meetings, because this is called special meetings. So the first category we have is regular meetings, and we talk about that later in the charter, right, Paul?
Yes.
Okay, so this is just for special meetings. We're saying that they can have special meetings, which are ones that are not normally as part of the regular routine schedule on 72 hours notice. Then we're saying there's a third category of meeting, which are emergency meetings. And we're saying that, number one, that the notice of the emergency meeting should specify what the emergency is. And 2, what are you saying about timing for an emergency meeting?
No less than 12 hours notice, to an emergency, and then you state what those.
I could also go with something like which is much notice as practical, because if it is
That's fine.
12 hour, if something's happening in 3 hours, do you feel comfortable, does everybody feel comfortable with putting specificity in terms of the emergency meeting notice, saying as much notice as practical under the circumstances, something like that?
Yeah.
Maybe?
I would say, I don't think it should have a time limit on it, because an emergency is just that, an emergency. So it could be 1 second
Right.
that if something occurs, you have to get on the phone or line
Right.
and say, we need to do something now.
Yeah.
So whatever now means, I think
I
that
think that's.
a number is not necessary. The other question I want to ask is in terms of ordinance. Is there something within the ordinance that describes what an emergency is? What is emergency defined? Because if it's already in the ordinance, then it can be referred back, that the charter does not necessarily have to have it, but that the ordinance will describe what it is that an emergency would make one activate on. So
So is
I'm
there
not-
an ordinance
I'm not
that
sure.
describes an emergency?
I'm not aware of one, but that is a good idea.
Well, Honestly, I think that emergency should be described a little more, like maybe like life safety, something like that. But if we're gonna call an emergency meeting on, at 2 hours' notice, I think it should be a life
Like,
life-threatening,
Yeah.
so I think that it should be I don't want people playing around with an ordinance and saying an emergency's, I don't know, when it's gonna be raining out, I want it to be, so I'd like to put it in here, I think we should be specified. So if you guys, with everybody's approval, Paul, if you could come back and you, Gabriel, could come back with language that sort of talks about this, gives us a good definition of an emergency, and basically say for an emergency, which is much notice is practical under the circumstances or something like that. Is everybody comfortable with looking at a draft that way?
Yes.
Okay, so we don't need to vote, that's what we're gonna do.
Let me just add a couple of things. Out of the statute, the language in the statute says the board or commission must provide a reasonable notice of all such needs. That's the first thing. And then I wanted to reiterate what I said about in the early 2000s. There was a fear of a run on this fund that held a lot of local government funds. And so there may be a financial reason too, there could be an emergency.
Okay, well, you'll come up with the definition and you'll put it in the draft. Yeah. And this is, what we're doing is consistent with the Broward County Charter.
Yes, it was.
Okay,
Okay, and that applies to municipalities.
good, let's move on. What's next?
Alright, next is 2.10, which is on the first page of the conflict chart.
Okay, what page is it?
And the section is,
The A2, A2.
Say it again.
A2, exhibit A2?
Yeah. Oh, I see.
and so, I'm just going through what was on the conflict chart. This is another one that you can probably disregard. So 3.10 provides for the swearing in of a new member elected at other than a regular election. But you can disregard the proposed
What page are
solution.
you on?
I'm sorry?
What page are
Page
you
one
on?
of the
One of the eleven.
Thank you.
On the very bottom.
On H2. And then you see my note in red there. So you can disregard the proposed solution that's in the conflict chart because there is a version of section 3.09 which, well, while not approved by this current board, I'm providing it because it was something that was approved by the former board and vetted by the supervisor of elections council at the time. And that is provided on page 2 of the materials.
Okay.
Yeah,
So
3.09.
this was a very important issue that the last board spent a lot of time talking about because of the situation that happened with the seating of the last commission with all of that and the objections and all that. So I think it's an important issue. I think that if you're okay with it, I think we should deal with it now and jump to that 3.09 section as to what the other board looked at. And so that, because I think it was a really critical issue that really didn't make the city look very well. Everybody was all right.
But is everybody fine with the 3.09 suggested language? Because
No, I was gonna suggest that we go over that language, so.
Oh, I was gonna say that looks reasonable.
No, I was just gonna say, let's go over it and see if everybody's okay with it,
Okay.
and then approve it. And then Paul's suggestion on 310 is then appropriate. So let's look at 3.09.
Yeah, because when I did the conflict chart and I put 3.10, the former board had not yet dealt with 3.09. So that's why my suggestion 3.10 was to
Okay,
become.
so let's go to 3.09 now. Why don't you go through this
And that's on page 2
of 11?
of 11.
Yeah.
So this was vetted with the supervisor of elections council at the time, and it covers regular meetings and special meetings. And so,
Like 3.09?
yeah.
Okay.
So, well, why don't I just read
It doesn't,
it? I'll start by
okay,
reading.
good.
On the date of the first regular city commission meeting after the certification of election results by the Broward County Canvassing Board, all newly elected officials shall take an oath of office and assume the duties of office. So it kind of simplifies it. It covers special meetings,
Where do you say
special
special?
elections.
Oh, you kept saying special meetings and then special.
Special elections.
Okay,
I'm
so
sorry.
this makes it very clear when these people are getting sworn in,
Yeah, it covers special elections.
And they have
as
to
well.
be sworn in.
and they have to be sworn in. Okay, my question, yeah. If, I asked this question before because I don't know why it sticks with me. If someone is re-elected, are they newly elected?
If someone's reelected. No, they are not newly elected.
But they
Because
do
this
have to be
says all
sworn in.
newly.
But I think here it means, I think here it's intended to mean anyone who's just elected.
Right, and my question, I don't know why this like sticks with me, but it says all newly elected office, and I'm trying to eliminate any kind of fooling around. So is there some better way we might say that, so that to cover a person who's not a new person in office, but has just been elected?
Gotcha.
How would we say that better? Because this one has like a little, I don't know why,
Or any commissioner,
Or it could be all persons.
Persons.
but maybe the word newly is not great.
Yeah, and newly is existing language.
I know, I don't like.
Yeah.
well, maybe just
Maybe just get rid of
maybe just
newly.
get rid of
Newly,
newly,
you
yeah.
just get rid of the word, and just say,
all-
all elected, all elected.
All elected officials,
Because they
yeah.
were elected.
Well, no, because some are already taken the oath, because if we go to staggered terms or something like that, then you're not, everybody's not gonna be, it's those, we're swearing in all those officials. Really, I'm gonna say it poorly, voted into office with the last election, that's not very good.
How about-
Well, you can add that to the end, this is intended to.
For purposes of clarity,
Yeah.
Or something like all officials elected at such election. Something like, I mean, we can work with it a little. I
on
don't
the
know.
date of the first, so after the certification of election results. Otherwise.
All officials elected at such election, something like that. We can
How about
play with
this, all officials whose election has been certified shall be sworn in.
Yeah, there you go.
Okay, something like that, yeah. Write it down, because I'll forget it, and I won't ever say it again. It'll be gone. Okay. Okay, so for this one, since we're fooling around with the but we're amending the language, let's bring a final draft of that back so we can all look at it. But conceptually, we're okay with this?
Mhm.
Yeah. Nadine, you good?
I'm good.
Alright. Alright, so that is 3:10 and 3:09, yeah?
Right, it renders moot.
We're gonna, okay, so, by the way, if anybody ever needs, yes, Nadine.
Oh, no,
You were just-
I'm just kinda thinking,
Waving.
again,
You're
when you
waving.
said all those elected officials that have been certified.
Yes.
Okay.
Okay, so if anybody needs a break for laboratory, for phone calls, just let me know, and it's a long day, so I don't want, people to suffer. Okay, alright, so we're gonna skip over, okay, now we're gonna go to, exhibits B1 and B2.
Yes.
So we don't need to look at the exhibits, let's just look at the language, which is where.
And we start with 4.6.
Page B2.
First
Page
page of
B2.
B2.
Alright, is this, so that's the section we weren't supposed to touch, we're looking actually at section 7.16 is what we're looking at, where is that? 7.16, because the manager asked that we defer on 4.6.
Okay, so I was gonna do the attorney's office memorandum in order.
I'm going through the agenda. The agenda says approved, section
Oh, the one there.
7.16, where is that?
That's on page 4.
Okay, got it. Alright, so this is something that this board has approved, but let's see, okay. Yeah, okay. So let's go at 7.16, which is approved by this board. Yes, on page 4 of
Got it.
Oh, that's an easy.
Just in the future, when you guys do an agenda, if you don't mind just numbering the pages sequentially instead of B2, B6, B.
Okay.
Just like number, so we could just say page 9, this is a little much. Okay.
Alright, so ready?
Yeah.
10.16, this is an easy one. It was an oversight when the charter was revised to eliminate primary elections. The recommendation is to correct the title of the section and delete the last sentence, which is ineffectual anyway because there are no longer primary elections. So,
Where are you?
each page
We're on tie vote, yeah? 7.16.
Yes.
on page 4.
Okay, the regular special election, candidates for each office shall receive the greatest number of votes for that office. Such regular special
No, that's right.
shall be declared elected. Tie vote between two candidates to the office of mayor shall be decided by lot, because that's it. That's what we're
Yeah, right, and so that was an oversight, there are no primaries, and that last sentence is ineffectual anyway, because there are no primary elections.
I don't like the word the. I might say each regular or city municipal election. Candidates for each office of the candidate. I think it should be candidate single. The candidate for each office who shall receive the greatest number of votes for that office. And we don't need to say it such regular or special municipal election again. We've already said it once. Shall be declared elected. The tie between two can, well, what's the convention that you're using in terms of numbers? Are you always going 2 then 2, or you just would?
Personally, I don't like it, I believe it's generally I think it's elsewhere.
Okay, so we don't need to change.
Oh, yeah, that's existing language, it's all existing language.
We don't need to change the rule. Okay, the tie between two candidates for the office of mayor or city commissioner shall be decided by lot to be conducted by the city attorney. The city attorney, we're giving the power to the city attorney.
Wow.
It's existing.
Yeah, I know.
Yeah, but we don't.
And don't forget, the point of my bringing this up is just the oversight with primaries.
We're trying to bring it up to give more power to the city.
Has it ever happened before that there was a tie
I'm
that was
not
determined by
aware.
lot?
I don't-
Okay,
I'm not aware.
just curious.
That'd be pretty freaky.
Does everybody know what lot means? Is that like common people know?
No, common people don't know what that means, but
No,
but to say, plan. I know you don't, you're not
People know.
common.
I think we're okay with the word
Oh,
lot.
no, I'm fine with it, but I mean, I think it
A lot
is.
of people don't.
Yeah,
Okay, all
especially
right.
if it were to happen.
Yeah.
You know.
All right.
Maybe when the city
Your
is
name,
small.
my name, and
Okay, so,
that way, that's what it means.
okay, so can I have a motion? Oh, we're gonna make those changes, you're gonna bring it back
But are you just changing one word?
to a couple. We're changing, yeah, why don't we approve this with those changes? We're gonna change
Each
The-
candidate.
to each, and then the candidates for the candidate for each office who shall receive. We're taking off the S, we're taking the S off candidate.
I'd move the stated change.
Well, no, and then I think you said who receives.
Okay,
I thought
we're
you said-
saying at each regular or special municipal election, the candidate for each office who receives, yeah, we don't need who shall receive, who receives the greatest number of votes for that office shall be declared elected. We don't need the thing repeated again. Tie between two candidates for the office of mayor or city commissioner. Do we need to say any commissioner seat, any city commission seat?
No.
Okay. Shall be decided by lot to be conducted by the city attorney. Okay. With those changes, can I have a motion to approve?
I'd move to approve.
Second.
Michael,
Michael,
I included the ones that I primary.
we're approving the blue language
Oh, okay.
changed by us. That's all we're doing. As we've just changed, yeah? Okay. All in favor? Aye. Any opposed? Okay, great. Okay, so that's that.
I think I think if that ever happened.
What?
Tie for one of these. You might as well just walk into the intercoastal.
You know
It'd be
what?
so bizarre.
There's gonna be so many recounts if there's a tie too.
Yeah.
Okay.
I don't wanna be here.
All right.
Next on the memo is section 10.03.
That's what
This has been, this has already
What
been
page?
addressed.
What page of the, where's the language?
Did we include it in this section?
I don't know if
We
it was in the
already,
first
we already did
section.
it. Yeah, we already did it.
So it's taken care of already?
Yeah.
So check it off, okay.
We did that in connection with.
And what about 312?
Same thing.
We took, okay, so check it off, right?
Yep.
Right.
Qualification of members serve close. This is, you did this too? 303?
303.
No, this goes back to Bernadette's question on the qualification. Let's go, where's the
Right.
language?
What
So you're
page,
gonna go
what
back
page are
to
you on?
page, you're gonna go back to the first page of P2, then go back,
Go back to what?
okay, go back about 3 pages.
It's got so many pages.
First page of B2.
Okay.
Okay, so where are we? Oh, we're
At the bottom.
okay, this is the point. You're
Okay,
raising.
yeah.
Crossing off this.
Go
Okay.
back one.
Good, Paul.
Alright, thank you. The previous charter revision board made a recommendation on this section, which deals with the qualifications of city commission members.
Could I just stop for a second? The background of this is, I think we also had watched it. There was a question about whether somebody lived in a particular district. The old charter said if one person files something, slows down the whole thing, and so they weren't swearing in this particular commissioner, and it was not.
Yeah, and I think something's changed recently where you don't have to, elected officials will no longer need to have their address public. And so with that, you know, there's gonna be if someone who's already in office, so what you would have to do with this language even that I'm reading now is you could still prove that the person didn't permanently live there. I mean, you could actually, because you were right, eventually this will go to court, most likely, even if this was determined. And that you would probably have to have an investigator go out like they did in whatever that city was in Miami. Go out, you know, and then once you go to court, that would be evidence
The two House
that.
representatives that were running.
Yeah, so I think we should, you know, the language, there should still be something in here that allows the city to review that. But just know that now the standard is gonna be a little bit different.
Okay, so let's keep that in mind as we read through
Yeah,
this.
it's not gonna be immediate.
So Paul, tell us, let's go through what the prior board did. I just wanted to give you the background in case.
So the board recommended that 3.03 be amended to clarify that candidates for mayor and city commissioner must: 1. Must have resided continuously in the city as permanent residents for at least 6 months preceding qualification for office. Must be electors of the city at the time of qualification. And the change there is that the current charter requires that they be over the age of 21. So to be an elector, that would lower it to 18.
So I'm reading, you're looking at 3.03?
Yes.
Okay, so for these 6 months, then they have to be a citizen of the United States.
Which is existing.
Right. And elected of the city of Fort Lauderdale.
So that
By the
changes the
way,
age.
my purpose, for me, every time it says city of Fort Lauderdale, I would get rid of Fort Lauderdale. We would probably cut the charter in half. I'd eliminate.
Just have city.
But just say city, I mean, there's no question about it. And I would, if it was me, I would do a whole clerical change in the charter, getting rid of these double numbers. I would get rid of the city of Fort Lauderdale, I would get rid of a lot of that stuff. I don't know if there's any.
That can happen, right? I mean, that can be a part of the
Yeah,
rewrite of
well,
it.
you do one question, which is shall the charter be updated to update, to clarify language, non-substantive changes to make the charter clearer.
Yes,
You know, I think it should be done, honestly, as long as we're doing this.
absolutely.
So I'm aware of your position, and on sections that
And you've spent hours drafting with me, so you know how I draft.
Right.
It would reduce
But
the.
this language is from the prior board before you brought that to my.
No, I'm just trying, I'm threw out a random thought,
Since you're doing it.
since we're doing it.
Yes, of course.
Okay, so, how do we do that? Okay, so whoever's keeping track, let's suggest to the city commission that they put one ballot question on updating, clarifying, non-substantive changes to the charter, just to sort of clean it up and to modernize it. So we're gonna maybe suggest one change to that. Michael, you okay with that, Nadine?
Fine.
I'm okay.
Nothing tricky?
Yes,
No,
that's
nothing tricky here.
Nothing tricky?
You speak in my language, commonality.
Commonality, okay.
And this is,
One second. All in favor of doing that?
Aye.
Okay, so that's that's a valid question that we're gonna suggest they do.
Doing it that way is great. When you
Yeah.
first brought it up, I was like, oh my God, we're never gonna leave this.
No, okay, so Paul, from now on, at least, when we redraft, Gabrielle, when you redraft, let's do it that way.
and this is new language, this is underlined, so it's easy enough to just change it.
Okay, anyway, okay,
Mr.
so,
Chair,
Now,
Mr.
what,
Chair.
the city,
hold on.
Quick
Yeah.
question. Should that be recorded as a motion? Everyone was in favor?
Yeah, we moved it,
Sure.
seconded, it
Thank you.
was unanimous.
Thank you for clarifying.
We're doing things very informally.
so now it would be referred to as the city.
Yeah, yeah.
Ivy Stranahan,
That's 21st
like that, but it's
Oh.
okay. Ivy Stranahan.
Well, I don't know her, so. Okay.
Mr.
All
Chair,
right. Elect-
excuse me, sirs, I'm so sorry. Since it's a motion, who moved and who seconded?
Michael moved it and Mary seconded it.
Thank
You
you.
didn't hear?
No, I didn't.
So sorry.
Apologies.
Thank you.
We'll look at you from now on like we should.
It's a long table, guys.
Yeah.
Alright, at the time of such okay,
So that changed,
shall be otherwise qualified to such, okay, so you wanna just read through this language carefully until we see if you're okay with it?
You're reading the blue part, right?
Yeah. How do you guys wanna deal with this? This is a long section, how do you want, how would everybody feel comfortable getting it?
3.03, right?
Yeah,
Yeah, I think we have to.
wanna just read through it
Yeah.
slowly, is that the best?
and I also suggest that it's probably easier to read the brief, but if you read the cross-out underline, you get the context of what's changing.
Well, you know what,
True.
I get confused, I think reading the blue is sort of where we're gonna end up. So anybody could read any way they want, but I'm reading. Okay, to be eligible to hold the office of mayor, the candidate shall have resided continuously in the city of Fort Lauderdale, we're gonna get rid of Fort Lauderdale, as a permanent resident for at least 6 months immediately preceding the date of qualification for such office. I'm gonna stop there for a second. We had a very detailed conversation about permanent resident, which I know you know all this stuff very well, because you were the supervisor of elections, what the word permanent resident means. We finally ended up saying the courts have determined what a permanent residence is, as opposed to trying to specify, you have to have your driver's license, you have your tax thing. That's sort of where we ended up last time, because there's been so many cases interpreting this. I feel comfortable with that, but I raised it to see if you have a different one.
No.
I think it's right.
Yeah.
Okay. Resident for at least 6 months immediately preceding the date of qualification for this office shall be a citizen of the United States of America and an elector of the city at the time of qualification for such office. Shall be otherwise qualified for such office as provided in this charter, shall hold, okay, are there other qualifications here that we're referring to? What other qualifications are there? If there are no other okay, just make a note to check it.
Yeah, there may
If there are
be-
and there's other qualifications, then that's fine, but if not, we should take out the language, because it doesn't mean it.
There may be something in 7.14,
Okay, just make a note to check it, please.
the candidate oath section.
Okay, but just,
Like, can't be up.
shall hold no other public elective office, shall not be an officer, employee, or serving in any capacity in the city government, city of Fort Lauderdale at the time of filing a candidate oath in accordance with, this is very difficult to read. It's too long of sentences.
Yep.
Nobody can understand it. I can't. It says, should not be an officer, employee, or serving in any capacity in the city government. So if you're on the charter review board, you can't run for office.
No, you have to give out a charter review board.
Yeah, you have, and I think that's standard.
That's
think it's
normal,
okay?
Standard procedure
yeah.
for any boards,
Any city board.
any city board,
Yeah.
any city board, right?
Serving in any capacity in the city government, okay. At the time of filing a candidate owed in accordance with 714 of this charter, except that a city commissioner may qualify for election to the office of mayor, and the mayor may qualify for re-election subject to, okay, Paul, you guys gotta work on this section.
I understand it.
Well, that's it, because you're brilliant. I'm not so smart, I just think it's too long of a sentence. It's like-
You get lost, yeah, you know, like.
Well, maybe you
Break it
listen.
up into smaller sentences and so on.
Pardon, you agree, Nadine?
I believe it's just a lot. I mean,
Yeah, I'm wondering whether it should be listed with bullet points or listed with A, B,
I like the
C.
bullet points.
yeah, burger dots.
Yeah,
You don't
What
see
are they
bullet
called?
points in the
Burger
charter,
dots.
they're not gonna be bullet points in the charter.
You got another name for it, what are they
Well,
called?
they won't let you bullet it.
Bullet,
Well,
I don't
just
think
saying, I
beauty
just think it's a
code-
lot.
allow it.
Or whatever beauty code
Okay,
is called
But
now,
I think there should
think-
be something that lists this stuff, this is impossible for anybody to read, and I want to be able to be.
I understand it.
I told you, you're brilliant,
Oh my
you get
God.
it.
This, but the
I think
general
it's good we talked
public
about it so
should
much,
be
the whole
able to
board
understand.
talked about it so much.
And shall reside this is another thing, and shall reside continuously as a permanent resident in the city during the term of office.
That's reasonable.
Yeah. Candidates for election as mayor shall comply with all the rules and regulations set forth in the charter as to their conduct. I don't know why we need that. Do we need that?
Is this new
Would
language?
you repeat that again, please?
So any candidate, okay, candidates for election as mayor shall comply with all the rules and regulations set forth in the charter as to their conduct. Is that new, Paul?
No.
No.
Any candidate for mayor, any candidate for mayor or any mayor who shall cease to possess the qualifications required herein shall forthwith forfeit his or her office or candidacy.
You added candidacy.
Right. Right.
And by the way, the only thing I did change was instead of set out, I made it set forth.
And the only qualification, and maybe this is what you were talking about earlier, is really just what you have to have done when you qualify, right? Just live in the city, pay the whatever, sign the oath form, whatever those are. Is there anything else that?
There's section 3.02, which is mentioned, that's creation, composition, and term of commission. That defines that there's a mayor and 4 commissioners. It defines, this is where the 3 years was changed to 4-year terms.
I thought we were gonna put a pin in this. You guys were gonna look between meetings and see whether there's some other qualifications that we're referring to. If there are, great. If not, let's get rid of it.
Oh, this is also term limits, so that's another it's another requirement. No person who's been elected, et cetera, for 3 terms shall be qualified for nomination.
Okay, so that's something, and maybe they're not, yeah.
Right.
That's a requirement.
And maybe you just refer.
So all that was, okay. Paul, I think we should divide this in parts. I think there should be a subtitle that says call for mayor, right? Because the whole section that we dealt with the mayor, right? It should be like a subtitle or something like that. And see how you can break this thing down in some easier way. And then the second big paragraph is for commissioner, right?
And they're similar, I mean, they're parallel.
Yeah.
Well, there's a little difference.
Yes, to be eligible to hold the office of city commissioner, a candidate shall reside continuously as a permanent resident of the city commission district for which such candidate seeks office for at least 6 months immediately preceding the date of qualification for such office. Except that in any year in which there has been a reestablishment of city commission districts, a candidate for this office of city commission whose permanent residence in the city of Fort Lauderdale is in a different city commission district as a result of the reestablishment may seek office as city commissioner in the city commission district of his or a permanent resident that results from the reestablishment. This is so something, that we talked about
This
this a
almost
lot.
happened, yeah.
We talked about this a lot. In addition, to be eligible to hold the office of city commission, a candidate shall be okay. What about this, Paul? There's a lot of these things that are applied to both the mayor and the city commission. I wonder if we have one section that applies to the mayor and city commission, both. And then we have specific sections that apply to the mayor and then when it applies to the city.
Well, it sort of is like that right now.
Yeah, but they're repeating a lot of this language again, twice.
Well, the thing is, the mayor is the whole city.
Yeah.
Commissioners.
Yeah.
They're more restrictive as to where they are.
Will you guys look at that and just see if there's some easier, clearer way to do this? I know we spent a lot of time drafting this section, okay. Yeah, in addition to be eligible to hold the office of city commissioner, a candidate shall be a citizen of the United States, candidate should be a citizen. And an elector of the city, like this is duplicate language. So for Lauderdale,
This will reduce the age.
should get time of qualification, shall be otherwise qualified for such office provided this charter shall hold another footnote to check to see whether other qualifications.
And then shall hold no other public office should not obviously apply to any city commissioner. So we just have to make sure that it can't be read like, if there is an exception, okay. Okay, keep going, okay.
Later in the sentence.
Okay,
City commissioner
Except
may
that-
qualify for re-election
Okay,
subject to 302
got it.
of this charter. It shall reside continuously as a permanent resident of the district to which such commissioner is elected during the term of office. Candidates for election as city commissioner shall comply with all the rules and regulations of the conduct a candidate for city commission who ceases to possess the qualification required shall forfeit.
good luck, Paul.
I got David a question.
Yeah.
David, we down there? So when somebody applies to run for, I'm just gonna make it up, commissioner. I mean, they go through your office, correct? I'm right? I just wanna make sure I'm correct. And I just always just figure that whoever gets it, yourself, checks to make sure their address, even though it'll be, blacked out to everybody else, is within the district, that their address qualifies them.
We'll check the address to make sure it's in the district, but we're not an investigative group, we take
Okay.
everything in its face, but we do put the address in just to double check that it's within the district.
Okay, so at the very
And
least,
that happened in the
Yeah,
past
there-
before I became clerk, actually, somebody filed for a district and you put down the wrong district.
And their job is really ministerial,
Yes.
so.
I just wanna make sure at the very beginning.
Although, and it's more of a courtesy, right? They're not really.
Yeah, it's more of just to make sure, 'cause sometimes they come in and they don't even know what district they live in, they're just more interested about information running for office, so I always tell them to go ahead and, go to our GIS map and put it in and do it, and we just, as a courtesy, that's the only thing that.
So that's really the only way we qualify somebody to run as a district commissioner. I mean, that's it, really, there's no other.
But I'm sure Bernadette has a lot of worse stories, but what happens is there's tremendous pressure on them. I mean, somebody comes in and they say, I did this and this and this, and the clerk basically has a ministerial function just accepting the paperwork.
Okay,
And then people say, why did the clerk say that this person didn't live there, and it's all that, and it falls on the clerk. It's horrible for the clerk. And then ultimately, the way that I think it should be up to the courts again. I don't think that asking the
Okay,
clerk to
yeah.
do that.
I just wondered,
I'm sure you must have some
Oh,
worse
yeah, I have
stories
I have a case just this year in March, and it was, in the news and everything, and the city prevailed, but it basically, the person checked that he was a write-in candidate, and then he said he really didn't mean to be a write-in candidate, but he checked 2 places on the official documents, and the clerk is not expected to do anything to help
So how did
change
that wind out? How did that end up in court?
Well, it went to court, and
Who filed suit?
the person who was saying that he wasn't a write-in candidate, and the city prevailed because the city clerk is just taking the documents, and they're not correcting your documents or reading your mind, so.
And I think that's the right way to do it, which is, and same thing with like qualifications of city commission, all this stuff. I think it ends up in the courts anyway if anybody's serious about it, and the procedure that the city has where one person can file a petition and stops the whole thing, which is what happened last time, right?
the time before election.
And it does, but it's at least good to have those procedures in place because not everybody files. You know, some people will go about their business, okay, maybe I didn't do it right, okay, next time I'll run, you know, fill it out correctly, and this is what your charter says, that at least gives the framework.
So,
Not everybody is going to go to court.
so do you,
Most people do, but not everybody.
do you think that, are you suggesting that there should be some internal procedure before the city commission where they make a determination?
No.
What are you saying?
I'm saying having, the changes I think that were made are reasonable. And I think that that's what it is. You look at the charter and you find you made a mistake, you may stop here.
Yeah, okay.
Yeah.
Okay.
Alright, thank you, I just wanted to make sure I had that right in my head.
Okay, so you guys are, substantively, we're okay with this language, and,
So want us to
I want
break
you,
it up?
I want you to do what you can to, a couple of things. One, confirm that there's other requirements in this charter, which it sounds like there are in terms of terms of office and stuff like that. So that language should stay in. Clean up the language so it says city, and then see if there's some way that you can, I wouldn't go crazy, but see if there's some way that you can make this a little bit more readable, because it's regular people that are reading this, and if they can read it more easily and understand, then maybe there'll be less mistakes.
So what I would probably do, I've always attempted to amend the existing language, and that's the process and underlines. So it would be a lot easier to just restate it
It's fine.
and not worry about cross-outs and underlines. In drafting, I think that would be a lot easier to come up with something.
I mean, once you get something, I mean, the program will do the crossouts.
But no, I see what you mean.
Yeah.
If you're trying to like duplicate language that you're leaving in.
Right.
Yeah,
And you're doing it right, that's what
Yeah,
you're
you're
supposed to do.
But to change it that much, I think we'll take just, I won't do the process and underlines, we'll just try to draft something and
And then you can do it later.
piece it together.
Yeah, just do it later, I think that's right. Okay, so that's on your list.
Question. As a city auditor, of course, I don't wanna make any changes, but I was just wondering on the title for section 3.03, it also includes the forfeiture of office, and there's a separate 3.8 for that, so I was just wondering if the title needed to have any kind of reference to something that already has a separate item.
Did we deal with 3.08 or no?
no, that's next.
Well, that's next, but 3.03, the title says.
Yeah.
You know, then it says forfeiture of office, but there's a separate section for 3.08 for forfeiture. I didn't know if you would wanna combine that in there. That's the first one I've seen like that kind of references to another one.
There is language about forfeiture at the very end, and it's for a specific reason. Someone who shall cease to possess the qualifications. So there is a forfeiture in this 3.03. So
Should we move the whole forfeiture thing under forfeiture and say it should be forfeiture of office or candidacy? And then put all the language dealing with forfeiture in one spot, or you wanna leave where it is?
I think it belongs here because it's related to possessing the qualifications that are set forth here. They're
I'm okay with leaving it there, but I think that then,
what we might wanna do, I mean, it's a good point, what we might wanna do is, although catch lines and titles don't really mean much, we could just get rid of forfeiture of office.
why don't we
in the
call
title.
3.08 absences? Or forfeiture by absence or something like that, so it's a specific thing, not just.
Well, why wouldn't we just get rid of forfeiture of office under 3.03?
Because there, in 3.03, there are some, at the end, says any candidate for city commissioner, any commissioner who seeks to present.
Title.
Okay, so that's a good idea, let's eliminate it from the title, and then in 3.08, put forfeiture of office dash absences or something like that, so people can find it easily. Thank you. Everybody okay with that? Yes? Okay. Alright, so that's 3.03. Did we vote on 3.03? Are we fine on it? Or we didn't? I think we're okay, well, we have a consensus to move ahead with 3.03, subject to some redrafting.
Right, I don't think we don't have to vote on that.
No, we're not gonna do, we're gonna vote on the final language when it comes, so everybody's here.
Want that tomorrow?
Well, I don't think they'll have a chance to.
At least she laughed.
Okay, 3 leaves left, okay. 3.0.
Hey, so by the way, I didn't point it out, but everyone knows we're talking about exhibit B1, that's the city attorney memo. Okay, that's the reference there, okay. And so 3.08 is mentioned on it, and as Pat just said, forfeiture of office, and that is on, what means page?
3.
Page 3.
Page 3, alright.
But we don't, and here,
So,
this was just a drafting thing, we don't include the mayor here. Just by any commissioner. This is a whole drafting thing,
there's a section,
Is there a section that says commissioners are intended to include the?
unless the context, is there, where is
there's a
that?
section that says, I believe it's 3.02, I think I have it right here.
Yeah, that normally it says,
The
There's no
mayor-
language that catches.
unless,
There's language that says the mayor and the 4 city commissioners are sometimes referred to herein as commissioners or the city commission. So that's why it's
And
written
that's
that way.
standard language.
Yeah. Do we have a section that Bernadette was referring to, because I've seen that too.
I see it now.
Yeah.
It's 3.08 and it's under forfeiture of office and it talks about absence by any commissioner from 4 consecutive
Yeah.
regular meetings, blah, blah, blah.
But do we need a section that says that when the term referred to commissioner,
It's already there.
It's in 3.02, that's what I was just
but
reading.
it's a little different than I've used to seeing. Read it to me.
It's the last sentence of 3.02. The mayor and the 4 city commissioners are sometimes referred to herein as commissioners or the city commission.
That's the
I
language.
think it's a one step further, which is when we use the term commissioners, it's intended to mean the mayor and commission unless the context dictates otherwise. It's a little different than this. I don't know. I think it's fine, sorry. I think it's fine. All right.
So the only issue in 3.08 that's in the city attorney's office memo is conflicting language about forfeiture of office and removal from office in section 6.06. And in fact, section 3.08 cross-references Article 6. So both are provided for your review, starting on page 3 of Exhibit B2. And
So
you'll
where
see
is
at the end of 3.08, it says, any member of the city commission who shall violate provisions of Article 6, section 6.06 of this charter shall forfeit his or her office. But then when you look at 6.06, which we're not really dealing with because that's civil service, the last sentence of that says, any violation of provisions of the section by a member of the city commission shall result in forfeiture of his or her office.
So it's consistent, right?
I'm sorry, that's new language. That's the suggestion. Any violation of provisions of this section by a member of the city commission shall be grounds for removal from office. Looking at the cross-out underline version of 6.06.
No, what we changed was that,
You haven't changed
One-
anything yet.
no, but what we talked about was one is automatic and what is grounds for removal. There's a difference. One's automatic, which is shall result in forfeiture of his or office. That's automatic. The other one, shall be grounds for removal, seems to talk about requiring some sort of action.
This is interesting. So, oh, I see. So the grounds for removal was was stricken and then result in forfeiture.
That's my suggestion now for discussion. This,
So how does that trigger, go ahead.
I was just gonna say that this is one of the observations of a former city attorney to put that on the list. Alan Barlow had put this conflict language on his list. Whether it's something that you want to address, it was just one of his observations.
Yeah, I just think it's going to probably cause a lot of confusion and possibly unnecessarily. But
The chances
Maybe I
are,
can think through it more.
I mean, there's such a blurred line between what commissioners do. I mean, I'm sure that regularly commissions call up and say to the public works director, hey, you mind taking a look at this, or just like stuff like that. Though, depending upon the way the manager operates his or her office, it's either very tight, in which I've been in some cities where they won't let their staff speak. But most cities operate much more loosely, and if something needs to get done pretty easily, it's non-controversial, they just do it. And so the idea of somebody losing office because they make a phone call like that.
Right, I think that goes far, and it may be interpreted different ways based on who you're dealing with. Yeah, you may be causing more
I think
problems
this
than
is, I think you're right, I think this is like a total non-issue.
Yeah.
I think.
Yeah, because what a lot of managers will do, is they'll tell their staff, do not take calls, you're not allowed to do that, you should refer them to me if you get a call from a commission. That will happen, and that happens a lot. Some will allow it with their knowledge or in their presence, but if you have.
Some are all the way the other way, which
Right.
is, listen, I wanna get stuff done,
Right. You're allowed to.
I'm very comfortable in my position, that you're not undermining me, so you wanna speak to somebody, that's fine. If something, and the department director then, or whoever it was, if they feel like it's something the city manager needs to know about, they would pick up the phone.
Sure.
And then it becomes an issue.
Yeah, but if this says, it will result in forfeiture, whoa, how
Well,
does that happen?
But also, even though it says grounds, it says result in forfeiture, it's the same thing, but who's gonna determine?
Right, exactly.
Who's-
Grounds at least tells you there will be a procedural something that will happen.
Let's leave
This
it.
just says it happens.
I
would,
I think we got enough to say, Grace, so I think we should just leave this alone.
exactly.
Is there, comment from the city manager's office about, do you have a feeling, do you have a comment, or you're just, no?
I agree with you all.
Alright, great. Alright, perfect. Alright, we're leaving this one alone, with due respect to the former, yes.
I wanna ask a question, what are the elements for forfeiture of a position, other than the fact that you are absent from 4 consecutive?
Well, I can give you a couple of them. If
But I'm
you-
saying, is that established someplace else?
Yes, there's
Okay.
the section we just read has like 5 or 6
Okay.
criteria. You have to live in your district, you gotta be a
Okay,
citizen of the United States, you
okay.
gotta be, I don't know what else. You gotta-
Okay, those are
So those are other things that you have to do, and if you somehow don't move out of your district, you forfeit your office.
But I thought those were the qualifications.
But there also, there's a sentence at the end that says that if you're your sitting commissioner or mayor and you don't meet those qualifications any longer, you forfeit your office. If scheduling's okay, I intend to take a break at 11 because Bernadette has a call to make and we could take a break anyway. Unless people can,
But please start whenever you need to.
it's all right, there's plenty to do and we're trying to have be very easy and congenial and let everybody recognize that people are busy and especially you've cleared your schedule in such short notice, so, okay. All right.
Oh, can I mention one more thing about 3.08? Substantively, the previous charter revision board recommended deleting the sentence in 3.08 that provides for forfeiture of office in the event of conviction of a felony in light of and recognizing the existing governor's statutory authority to suspend and remove municipal officers. Do you want to revisit that issue or let 3.08 go?
I'm not sure that I'm following you, I probably need to look at the language, but
Take a look at page 3.
I would think that if there is a felony and someone's been convicted of a felony, we don't have to wait for the governor to remove, that person should probably not be there. And if it's in the charter, that would probably be an appropriate place for it, but
Would you want to leave that?
I haven't looked at it, so.
Yeah, right, so on bottom of page 3.08, it says any member of the city commission who shall, this is current language, who shall, while in office, be convicted of a felony, shall thereupon forfeit his or her office, notwithstanding any appeal or right of appeal he or she may take. I I sort of feel like the governor's office is pretty quick to move in sometimes, and sometimes very slow.
Sometimes,
Sometimes
it depends on the party.
Depends on the party. The party, capital P or capital small p. But I was a little concerned, let's say if somebody's convicted and they're appealing, should they be removed from their spot,
I think so.
even though they're on appeal?
And
then-
sometimes those appeals can last very long.
I know.
We have a,
But what happens if they win? And now they've
Well,
lost
right.
2 years of their service.
they can come back and
Sue the city.
sue the city. No, I'm just kidding. No, they won't sue the city.
Okay, so is there a thought here about, well, that we should leave this alone? The language that was eliminated by the prior board? Leave the language here. So if they get convicted of a felony, which is clearly defined, the word felonies, everybody in the state law defines felonies. Should they automatically forfeit their office notwithstanding any appeal?
That's what I think.
That's the current language. Does anybody have a urge to change that language? Are you okay with it the way it's in the current charter? Okay, we're gonna leave it. Okay. Now that we've defined, is the four consecutive meetings worth discussing, or people are pretty much happy with that? Leave it alone? Okay, let's go.
So, excuse me, sorry. The only change you're making to 3.08 is in the title?
Yes,
Can we approve that since it's just the title?
yes. Motion by Mary, second by Nadine. All in favor?
Aye.
All opposed?
Is that absence or absences, or I use my judgment?
Use your judgment. I so move you use your judgment.
I think it's okay, the language. Absence by any city commission.
No, in the title, we're adding absence or absence.
Whatever, I'll leave it, that's up
My
to,
judgment.
yes, I'll leave it.
Excuse me, Mr. Chair, just for the motion to be very clear, not subject to interpretation. Do you wanna restate how you want it reworded, cause you're changing just the title?
No, we're just, all we're doing is changing the title.
Right.
Section, we're approving section 3.0 as is, with just a change to the word, just to the title to be determined by the city attorney's office.
To be determined by the city attorneys, thank you.
Okay, good, I'm glad to know that's an answer.
Alright,
No, okay, good.
7.16, I think we covered.
no, we didn't.
Yeah.
You talked about it,
Okay.
A lot?
we talked about it in June.
So this was an oversight when, yeah, we did.
We
It
did
was an
some
oversight when the
questions,
charter
yeah.
was revised to eliminate primary elections and
We changed some words and got rid of
changed a
it.
few words and got rid of the S and added an S.
Yeah, we approved
Oh,
that.
yes, 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 yes.
The only reason I mention it is because it's also on the city attorney's memo.
Okay, so it's off. So we're done with this, yeah?
So Article 8, which is the last one on the city attorney's office memo, I'm not sure what was meant by that. I'm not aware of a conflict with state law. Maybe what was intended was, to be for the city to do it the way the state does it, but I'm not aware of any law that conflicts with how the city deals with city property. And
Okay, so you can't figure it out, let's just
I
check it off
I
and
wasn't
say
able
that.
to figure it out.
Alright, fine, how about 8.02? I mean, we're gonna go through section 8 because it's a somewhat of a hot topic.
I'm sorry.
I'm sorry.
Just before you leave, 8.01, this is just, the new language is the new language, and it's just basically a sentence that refers to whatever you establish as the ordinance, right?
Yes.
Okay, got it.
Okay, this is a new category, Article 8, we set that out separately.
I wanna go through Article 8 once and for all, from top to bottom, and figure out what we're doing. Because we've talked about it here, talked about it in the other board, let's try to be.
We covered quite a bit in the last meeting too.
The reason I mentioned it a minute ago was because that was also on the city attorney memo. So I'm doing everything in order. So overall, from the city attorney's memo, what was mentioned, conflict with state law, that's what I was saying, I'm not aware, I'm not familiar with one. Alright, so now the next,
Conflict in terms of what to do with personal property or whatever that is. With the sale of property, is this intended to like relate to surplus property?
so back to the city attorney memo, it simply says the notice requirement for sale or leases of public land should be consistent with state law. I'm not sure what that means.
Nobody could argue with that.
I'm not sure what that means.
Consistent,
Where
whatever it is.
where are we in
It's, yeah, it's,
Would be consistent.
yeah, right, okay.
Now, moving away from the city attorney's memo, let's put this all in order. So moving away from the memo, we also,
Well, before you even move away from the memo, let me just ask this question so it won't linger in my head. Personal property, what is that supposed to mean, personal property?
non-real estate,
Okay,
personalty.
oh, okay, okay.
And we had
Anything
that-
that's
we
not,
discussed that
anything
too.
that's not real property,
Is my understanding.
okay.
It's not.
It's not real.
That seems to be
It's also
odd
not,
as
it's also not intangible property.
okay.
Is it like the blotter on your desk, your personal
Your
blotter?
chair.
Yes.
Is it your
Chair,
chair, picture of your
furniture,
dog, your cat?
Yeah, does the city really have personal property? I don't know.
Oh, wouldn't this,
I think
their
it's just
furniture.
distinguished from real property.
Okay.
I think personal property is chairs,
Okay, okay.
stuff like that.
Vehicles,
Vehicles,
your laptops, everything.
laptops,
Screens,
screens,
furniture,
coffee cups,
everything belongs to the city.
everything belongs to the city.
Everything
Alright,
that
so-
legal would support.
So we're gonna, once and for all, we're gonna go through this 8.8, Article 8, one by one by one, and we're gonna
Gonna get it done.
get it done.
So the way we divided it, is in this section C, Article 8 are the sections that have been approved by this board.
Yeah.
And then at the end of the meeting, we have the
New.
rest of Article 8 for new business.
So for Bernadette's sake, let's go through what this board already did on this and make sure you're comfortable with it, or you wanna look at it more, however you wanna do is fine. But this is just sort of where we were. Okay, so in 8.01, we just clarified it, we said personal property shall not be sold except for by ordinance.
And this is Exhibit C, everyone.
And Paul, I would say there's no reason to have this in the negative. Why don't we say personal property belonging to the city shall be sold pursuant to procedures established by ordinance. There's no reason to make it like a negative.
6 of one, half
Yeah,
dozen of another.
Again, that's existing language, yeah.
I know, but that's okay. So 8.01, final, Bernadette, you go with it?
I'm good with it.
Okay, so 8.01, final, moved by Michael, seconded by Mary, all in favor?
Aye.
Opposed? Done. Okay, so we're done with 8.01.
Yep.
Paul,
At the
I'm
risk of
if we're
belaboring.
not done, I'm gonna kill you.
Well, in light of the last change, making it a positive statement rather than
Yeah.
a negative, shall be made.
I think you should just leave the words alone. It's okay to be a little negative.
No, I think shall be shall, because then you'll have nothing else to look at, and it should be.
In positive though?
Well,
Personal property belonging to the city.
if we left it like it was, that's how I'm viewing it. Shall should be shall.
Shall be sold.
Not to
As
contradict,
provided by
shall
ordinance.
not
Right.
be so.
Should not be so.
What did you?
What we do?
That's
Shall,
motion?
yeah, well,
Okay, but so we can revisit. What do you say should be?
I don't think, I think it's fine. I think it's fine.
The blue language is fine?
Yeah, the blue language is fine.
Okay, we're
And
gonna
I-
revise what we really did
Mhm.
and poof, we're just approving the blue language.
Yeah,
Done.
As proposed.
As blue, on the blue, just put it, we're approving the blue language,
I like writing this word right.
blue language, not changing a word. Okay,
And by the way, these are things that this board has already approved.
I know, but
That's why when
we're
you
making a poof, this is the way we do things. Alright, okay, so 8.02.
Alright. 8.02, the proposed revision.
Okay, just to clarify, this is just sale or lease of city property to public bodies only. This section is only to public bodies, right?
Yes.
Okay, good.
The proposed revision requires a public purpose for the sale or lease of property to public bodies. We added lease, I think that was a discussion. To public bodies or the allowance of a public body to make improvements on property owned by the city. And it defines public purpose, as you recall, there's a lot of discussion about this, based on case law as, quote, an activity that is essential to the health, morals, safety, or general welfare of the city, as determined by the city commission. And at the last meeting, you asked me to add, you asked me to reword it a little bit and add notwithstanding an incidental benefit to a private party, to the last sentence. Because as you recall, we were talking about paramount public purpose,
Right.
and there must be a paramount even although there's an incidental benefit to a private party, and then what you ended up asking me to do is add notwithstanding an incidental benefit to a private party, and that's added to the last sentence.
Okay, so we're basically saying, in order to lease or sell to a public body, you need 4 commissioners. For a public purpose, and then we define it, and then we have that little section that we added at the end about the incidental benefit.
And I don't think you specified where to put it in the sentence, so I just my judgment.
I think you did.
Good.
Okay. Does anybody need another moment to look at this, or are we good with this language?
I'm good with it.
Notwithstanding an incidental benefit to a private party.
Right, so if we determine, what was the example, if the city determines that it wants to,
Snack bar or something.
no, that they wanna lease to Broward County some property that we have, and Broward County intends to, because they need a snack bar in some nearby one of their parks. The fact that somebody's gonna run the snack bar, private party, and make
Okay.
some money, is
I
not gonna be, is not grounds for not doing it.
And that's the incidental benefit.
Yes, that's what we
Got
talked
it. Okay, got it.
And that comes from the poll opinion from Lismore County, which you're probably familiar with from about 20 years ago.
An incidental
bond
benefit,
issue.
yep, got it. Okay.
Okay, so good, so, we're done with 8.02, we've previously voted on it, is everybody okay with that? Okay, all in favor of 8.2 as it is in the blue language? Motion by
I'll also motion.
Mary comes through.
Second.
Michael second. What?
I heard it say 8.2.
8.02, yeah. All in favor?
Aye.
Great. Okay, what, just for my own, what happened to 8.03, was there no 8.03?
We haven't.
So it's on, we haven't, okay,
It's an exhibit D.
yeah, we're gonna do 8.03 later. Okay.
Yeah, there's the one
But if there's something in one of these sections that we're skipping that relates to what we're doing, you need to bring it up now. What is 8.03 about?
Looking it up right now, I'm not gonna sign it.
8.03 is acquiring right of way for purpose of conveying same to a public body.
Okay, I'm done, it doesn't affect what we're
Do you
doing.
have any?
Okay, so 8.04 is sale of real property to private parties.
Okay, so the charter revision board recommended amending
Let me just stop for a second. This has been very controversial with all of these stop, swap, shop, and the pickleball courts and all of that kind of stuff that has raised issues as to when the city is selling real property or leasing real property.
The P3s.
The P3s, that kind of stuff.
Exactly.
Is it the right thing and what's the proper procedure and all of that, so that's what this, okay.
So, the board recommended amending this section to provide that the city's sale of real property to private, this is only sale. Okay, so the city's sale of real property to private parties be as provided by ordinance and consistent with applicable law and subject to adoption of a resolution by the affirmative vote of at least 4 commissioners containing a finding that the sale would be in the city's best interest. Now, one of the things I added was consistent with applicable law because One of the things I could think of was in the case of eminent domain, if the city acquires property, then there's a right of, and then wants to sell it, then there's a right of first refusal or something like that. So I threw in, consistent with applicable law. And then there's a caveat that section 8.04 is subject to section 8.21, which, if adopted, would require a special and I'm planning to address 8.21 a little later, but I might as well now since it's mentioned. So 8.21, if adopted, would require a special election referendum to sell or transfer any land, zone, parks, recreation, or open space, and would require a unanimous vote of the entire city commission to enter into any lease, license agreement, concession agreement, facility use agreement, or other type of use agreement for more than 1 year with respect to.
Is there anything else other than that in 8.21?
Is there anything else? I'm sorry?
Is there anything else in 8.21?
8.21 is
Just dealing with parks. Okay, should we, it's a sale of real property to private parties, should we have 8.21 be in here as opposed to referring to? Is there a reason to have a separate section? So if somebody's gonna, the city's gonna sell property, they look at this section, they see this is what applies to regular property and this applies to parks property. Is there a reason?
Well, 8.21, remember we split into several paragraphs regarding lease and sale. And so 8.04, we're only talking about sale, so the cross-reference of 8.21 really only refers to the sale part of 8.21.
Right, and should the sale part be here and the lease part be under leases? Or is it better, do you think, to leave it in disposing of park property?
I think well, there was the charter was amended in around 2004 to make 8.21 say what it does now.
I'm just talking about drafting. Should the sale of parkland be under sale of real property and lease of parkland be under lease of real property, or it should be a separate section disposing of park property?
I feel it should be separate
section.
Fine, okay,
That's me, I don't know if
Fine.
anybody else does.
okay. So this is where we ended up on this, which is they can sell property. It takes 4 votes, right?
That seems like a high bar.
That's okay.
I mean, I'm just thinking, okay, the sale of property, first of all, I guess there's not a whole lot left to sell or lease or convey or whatever.
Well, it could be even improved, it could be the old city hall site.
No.
The reason, and I need to interject this, the reason why Mary interjected separate, because Mary is institutional, you sit on the Hawks, correct?
I did, till I came
You
here.
did, yeah. So that was a very key issue, because I always remember hearing about it, and that would be a very big commonality, a very big problem with the residents of the city.
Okay, so you think it sort of de-emphasized it by taking it out?
Absolutely.
All right, so let's leave it.
So I get the parks and why that's a different standard, but if there is, let's say, the city property or the new city hall or whatever there's a P3, that's proposed.
Correct.
It just seems like
It's tough.
that's tough. And if you think about just the last few commissions, and the current commission, I don't know, I just think that would be, that's a very high bar.
Would a P3
Could be a sale, or it
would
could be a
involve a
P3
sale?
sale, or it could be
P3 would be a
It
sale.
could be where you're
selling, you're selling the property and putting up the whatever.
Sure.
I feel it this way. I'm protective of city property, and once you sell city property, it's gone. So
But if
If
it's
one
for a
person-
public purpose,
if one person objects, I think, and they should be able to hold up the deal. But if 2 members of a 5-person city commission have problems with what's happening, I think maybe it shouldn't happen, because it's forever.
Once it's gone, it's gone.
It's a judge, it's like a question whether you want to try to make it easier to do this or harder.
Yeah, so I think that, and I'm thinking in terms of the P3s, I mean, there are a lot of touch points, there are a lot of requirements, even in the new statute that require that cities appropriately evaluate these deals and have the right professionals in place who can help determine whether these are good deals for the city. I mean, the statute, the changes aren't all bad. So so if it is a true partnership that's providing a public benefit, it may be that this group needs the land in order to make this deal work and to save the city money or have parking or what, I don't know. But so I'm just kind of thinking, and I hear you, and I'm not opposed, I mean, I'm fine with it, but I'm just kind of thinking out loud
By the
about.
way, also, doesn't have to be a P3. This
Right.
is just selling city property.
Mhm.
And it could be just, okay, we have this property, developer wants the property, they get 3 votes of 3 city commissioners, and they vote it and the property's gone. That's the most.
Two questions I have. One would be, and this is, I guess, a management question. How much city property is still available for sale? Where are those? Is there a map that you guys looked at? And then the second question I have is, what is the foundation of the change? Like, did it happen with the last board and something like that?
Where did this come from?
Is it proposed by city staff? So I'm,
Came from, the big topics for the last board were how the elections went. That was one. The second one that I forgot. The third one was dealing with disposal and all these properties. That's where it came from. And, so that's where it's not being proposed, but it came from the Charter report as an issue that citizens were concerned about.
I see, okay, thank you.
So, being on the parks board, when all this was kind of coming about, it came to light that a lot of the parks were not zoned as parks, which freaked everybody out. So I think we've got them all now zoned properly, but I mean,
We did actually have a big list of all the city property.
Yeah.
Somebody produced
Yeah,
that.
I would love to see that, just to get an idea of what
But it also could be
Uh-huh.
where it could be like an existing city hall site, it could be within it could be the public works building. And they say, okay, we're just gonna sell it, and my experience, 3 votes, not so hard to get. 4 votes, hard to get.
yeah, you better have a good reason.
Yeah, okay.
With regards to P3s, let me just mention, Gabrielle brought
I'm just
something to
looking
my
at that right
attention.
here.
The statute, P3 statute, where it addresses the comprehensive agreement, does say for the building, or it says for the building, upgrading, operating, ownership, or financing of facilities. So that may or may not actually address the underlying real estate.
But there may be more protections in a P3 situation than in just a plain sales certificate. But we are gonna break.
Oh,
And let us, how much time do you think you need? Do you have any idea?
I don't know, it's a calendar call,
Okay.
so,
you need a quiet room?
yes, no, I'm gonna go right out in the hall.
Okay.
So when you need to start,
We're gonna
start
take a
again,
break.
just start again.
We're gonna take a
Yeah.
break for 15 minutes and see if that does it for her and then.
Yeah, for sure, well, all right.
You and I were having this discussion as to, okay, so what do people feel about the 4 votes versus 3 votes? Michael, maybe
Steer with the full vote.
Well, meaning we had a discussion on the record, that's what you're referring to.
we had a discussion on the record.
Prior to the
Thank you very much. Thank you,
Yes.
my attorney, she's protecting me. She's on the-
Protecting both of us.
Thank you. Okay, so the discussion we had on the record was whether we needed the protections of 4 votes or whether it should be we should be more facilitating and allow 3 votes. So what is your thoughts? What are your thoughts?
So my thought is, once something is sold, it's gone. And we should be very careful about real estate. There's just, I mean, look at it, there's just not very much left. And I think it should be 4 votes. I think it should be not an easy thing. You never know what commissions are gonna be like in the future. And that's the way I feel, that it should be, there should be 4 votes.
And if that's the will of the committee, that's the will, and I'll go along with that. But I still am interested in knowing what property is still available.
Let's so someplace along the line, we had a list of vacant, because there's lots of city property that's occupied. Are you interested in all the city property or vacant?
Well, whatever you all saw at the time would be
Somebody had it.
I don't want anybody to do any research.
Anthony, can you get it for us? No, we
It
had
was
it.
interesting to
No.
see.
We had it.
Came from risk management.
Came from risk management, because we looked at what they were insured, okay.
And
So,
we looked at values.
Michael, where do you
I'm
stand?
definitely in favor of all 4 stations.
Nadine?
Still at 4 votes.
Okay. So everything doesn't have to be unanimous, but I'll make a motion that we leave it at 4. So I have a second.
I'll second it. Are you seconding it? Or this is your
Raise
habit?
your hand for lunch.
Okay.
Raise your hand for lunch.
Okay, Nadine.
Yeah, for lunch too, but.
Well, she's awake, it's after 11 now, so.
It is right. So, I guess we should take, because you may wanna vote differently, let's do a roll call on
It's
this.
not necessary.
Okay, so it's okay?
Yes.
All right, so unanimously, we're staying with 1. Okay, you sure? Okay. All right, so, Paul, I just asked a question about B. Do we need B? Do we need to say that they're authorized to pay real estate commission? I mean, normally cities have the power to do anything they can unless it's prohibited. Is it prohibited? I mean, why is this here?
Well, first of all, it's existing language.
Well,
And and second of all, as opposed to the procurement code, it may be good to have it separate here so that you don't, it's not subject to the requirements of the procurement code. That's probably why it's here.
I've never even seen this in a charter. Have you ever seen it, Bernadette?
I want to make sure I'm in the same place.
Page 5,
Okay,
You
got
are
it.
right.
on the top of page
Okay,
5,
got
the
it.
blue language. Have you ever seen this before?
Authorized to pay a real estate
So,
commission.
doesn't mean they have to, it just means they're
Any
authorized.
registered real estate broker licensed to do business
They're
in the
authorized.
state of Florida. Negotiates. Yeah, I think it's odd language for the charter.
Don't you
but-
think so?
Yeah, I do.
I think the reason though is when you have a contract for purchase and sale, or if you have a contract with a real estate broker, it might be outside of the procurement code, I'm not sure. And we have, I have to look.
I don't think I read this provision. I've never seen it in.
Let me ask a question. So when the city buys property for use in parks, that's obviously my only experience with the city purchasing property. We had a realtor, not a city employee, but contracted by the, I forget his name right now, that Collier, right? Goes out and looks for property for the city to buy for parks. I mean, I don't know, do they collect
They get paid.
they get paid well?
Normally the real estate commissions are paid by the seller.
Correct.
And that's why, so if the city sells property,
Or because they are buying it.
so the
So the
other
seller
side,
would
the
pay.
seller would probably pay.
Okay,
I mean, it could be split up in a different way, but
Yeah.
generally the seller is the one who's paying the real estate company.
and they split it with the,
And they do
They
whatever,
split it.
they do whatever they want with the buyer. If the buyer has a realtor, they can split it in some way.
so does our buyer get to have, they usually share the commission,
If, first of all, there might be only one realtor, in which case they would, the seller would, the city would pay the full commission to them. There could be a buyer's real estate agent, in which case there'd be a negotiation between the buyer's real estate attorney, real estate agent and the sellers as to how they split the commission.
So I'm looking at the procurement code, there is an exemption.
Which is an ordinance, yeah.
Yes, there is an exemption for, and this is exemption from the $100,000 threshold and also competition. Real estate transaction related costs including closing/processing fees, abstracts of title and title insurance. But brokerage fees would be different, and or real estate commission fees might be different, and I don't know that they're addressed. So
But they're not in that sentence you just read.
right, so that may be well, the procurement code could be amended to address it.
Right.
Okay.
I think it's like pretty unnecessary.
I don't know, I just don't know, don't go by
But I
your
think it would have to be
expertise.
amended
Okay.
to, if you take it out of the charter.
Okay, I'm gonna recommend that you speak with, there was a real estate attorney that as in the city attorney's office, right? She was gonna come to a meeting or something, and I don't know what happened, but anyway, check with her. If she feels this needs to stay, that's fine. If not, I'm gonna suggest that it go out. Just because it's every city pays real estate commissions, everybody does it. I've never seen this in a charter before.
Okay.
Okay, so let's move on to the next one. Okay, background 8.09, Bernadette. This was they were calling things also, they were calling leases, use agreements and all of other things to get around the word lease, right, Paul? I'm not saying that, you don't have to, I'm not asking you.
Yeah.
Okay, there was some,
That's one
there was
characteristic.
some people thought that they were calling things concession agreements to get around the provisions in the existing charter dealing with leases. And so the conversation at prior boards was that it doesn't really matter, you can call it whatever you want to put on top, it's still whatever it is, it's transaction, a license, a concession, a use agreement, whatever, they're all the same, they should be treated the same in terms of the charter.
Can I add one thing? So if something is truly a license agreement, then to terminate it and to get the person or the entity off the property, it's easier than if it's a lease because you don't have to go through the eviction process. And that's one advantage to, and it's not just calling it a license, but that's an advantage to having license agreements. Now, whether they fit in particular situations, you know, whether it's actually a lease or a use agreement or a license, that's another discussion. But there are advantages to using license agreements.
We're not prohibiting, what we did was, if you look at the blue language, which takes a couple of pages, okay.
So I can explain it.
Yeah, it's on page 7.
So the board recommended amending 8.09 to clarify that all use agreements, including leases, license agreements, concession agreements, facility use agreements, and other types of use agreements with private parties for the use of real property owned by the city are subject to a 50-year maximum, including any renewals or extensions. The City Commission's approval of such an instrument will be subject to the following. Approval of an instrument having a duration exceeding 1 year would require a resolution adopted by the affirmative vote of at least 4 commissioners containing a finding that such use of the property would be in the city's best interest, and the City Commission's consideration of a fair market value analysis of the property prepared by a qualified independent consultant hired by the city at the private party's expense. And in addition to the requirement of a fair market value analysis that I just described, the approval of an instrument having a duration exceeding 10 years, including any optional renewals or extensions, would require the City Commission's consideration of an accompanying business viability report prepared by a qualified independent consultant hired by the city at the private party's expense, and each instrument must contain a provision prohibiting assignment except upon the affirmative vote of at least 4 commissioners.
Okay, just to summarize, so there's 3 or 4 different categories. Less than a year, just required, correct me if I'm wrong, less than a year just requires 3 votes, no matter what you call it. More than a year, but less than 10 years, right?
Requires
Requires 4 votes
and a resolution.
and a resolution. And then more than 10 years requires 4 votes plus some other stuff. And is that, am I correct on that?
That's all.
Okay. That's sort of where we were.
So anything over 1 year would be
4 votes.
4 votes.
Yeah, that's, again, I guess, it not only makes it hard to do business, and I guess I'm thinking of it from that vantage point, but also, just to have to consummate a lease agreement, to have 4 votes, it just seems like a lot. Maybe if you have the longer terms, maybe if it's, longer than 5 years or longer than something else that's reasonable, but, you're not deeding property, it just seems like a high bar. So here's a question I have. I know this is just an advisory committee, so whatever we take to the commission, they can either accept or reject or whatever.
Modify or not put on the ballot or throw in the
Yeah.
garbage can.
Yeah, and this and this is probably one that, might, lead in that direction. I can tell you, if it goes on the ballot, voters will approve it.
They will.
Yeah, absolutely, voters will approve it. But I just don't know that it's, at least for the shorter terms,
Okay.
it's necessary.
Let's see what other, Nadine, what's your thought on this?
Well, that's why we're probably in some of the predicaments we're in right now with the land and everybody having a right to be aware and informed about what has happened in the past as well as what can happen in the future with the remaining land that's there. So it gives an opportunity for those who may not truly understand it all, but with 4 votes, that means that all communities are unanimous about the feelings or what happens with land in the community. And oftentimes when it's less than a unanimous vote, it gets manipulated. And I think for now, at least over the next few years, that manipulation needs to be taken off the table.
Michael?
I underscore what she just said.
Now, you guys realize it's not gonna be a unanimous vote, it's just a super
Well,
majority.
among the commissioners,
Okay, gotcha.
yes,
And
that's all
it's a
we're speaking
super
about.
majority.
Yeah, because
Yes.
I've seen some really helter-skelter votes go down and issues and items that were there regarding the public land that was being sold and being leased. And I'm not gonna get into what issues I'm speaking about, but I think we're pretty well aware and intuitive of exactly what happened. So if all 4 commissioners vote in favor of this, I truly feel that we're doing justice for the people. That's what I see.
Revision?
Ask the public to vote on this,
Jerry?
Well, I think Nadine, put it, perfectly. Now, of course, you're right, not all 4 could be 3 commissioners and the mayor, but still it gives the chance for all 4 districts to have a voice in the decision about, property. And I've been a big proponent all along of the 4 votes. I know it makes it a little bit harder to do things, but I think that's probably not a bad thing at the moment. I might regret this 10 years from now, but right now, I'm just, I like the 4.
Okay, so I have 2 different thoughts about this. First, I'm questioning all of this other language in there. The resolution and the reports and all that kind of stuff, and whether it's really, we elect these commissioners to do their job, and if they feel like they need a report, the question is whether it's really necessary to have all this language requiring a report and a feasibility study and all that. But I'm also listening to Bernadette, I'm wondering whether 1 year for 4 votes, could we slide it a little bit to make it a little bit easier? could be 2 years, 3 years in the requirement. But I don't have a super strong feeling about this, I think others do.
I just feel like it's a slippery slope if we let it,
So,
you know,
Okay.
be easy.
okay,
But that's me, and I don't necessarily have, I only know what I've seen.
yeah, well, there's a lot of that maybe the pendulum swung a little bit too far one way or the other way. Okay,
And
But-
I don't have a strong position on this, I'm just trying to be practical in terms of raising an issue that seems glaring to me at least, that for short-term engagements, I don't know that you need a supermajority vote, but that's it.
okay. So would you wanna make a motion to slide the 4 years one way or another, or you're?
No, I don't think there's an appetite for that.
Okay, all right, so,
I love you.
all right,
By the way, a slight distinction from supermajority is the number of 4 votes. So if at any given time there are only 4 commissioners, if a seat is vacant, 4 votes would work here. In other words, it's not a 4/5 vote necessarily, it's 4 votes.
It's 4
And I think that was
votes,
done on purpose.
okay,
But assuming you have 5 commissioners sitting, it
Then it
is
would
a
be a
supermajority.
supermajority, yeah.
my sort of feeling is that 2 out of the 5 commissioners feel like it's not a good deal. Maybe it's not a good deal. So maybe I'm willing to slide the scale a little bit towards being more restrictive. Again, I don't feel super strong about it. Okay, let's make a motion, Mary makes a motion to leave it the way that we had drafted it. And
And I
it's
second it.
happily seconded by Nadine. And all in favor?
Aye.
Aye. Bernadette, yes?
I said aye.
Okay. Okay, I'm not picking you, I'm not.
Yes, you are.
No, I was trying to give you the opportunity to say no if you wanted to, that's right. Okay,
8.21.
Okay.
So the board approved the revision of 8.21 as I described in connection with the exception to 8.04, and I can go over it again.
yes.
So redrafted 8.21, if adopted, would require a special election referendum to sell or transfer any land zone parks. And they actually started that to use the correct
Forest recreation open space.
park, recreational open space, and would require a unanimous vote of the entire city commission to enter into any lease, license agreement, concession agreement, facility use agreement, or other type of use agreement for more than 1 year with respect to any land zone parks, recreational.
I don't think I asked this question before. Does this also cover P3s? Or is that a whole separate entity of its own?
You know, I was wondering about that too, because you could end up with some kind of lease or use agreement or license agreement out of them. B3 would end up with a comprehensive agreement, but the comprehensive agreement could involve or could be a lease, license, or some other kind of use agreement. So that's a good question. That is a good question. Now,
Say that, go ahead, ask the question.
So P3s, how does that work with this?
P3 is gonna be,
Is it its
either-
own ordinance,
it's-
or, I mean, that's all, it's all changing.
the P3 is it's gonna either be a lease, a license, a concession agreement, a facility use agreement, or other type of use agreement for more than a year. It's
So
gonna be
as
something-
described in
I
here.
mean, yeah, it could be,
but it'll have the title, if I may, it'll have the title comprehensive agreement,
what do you say, why would it have that?
because that's what the
Yeah.
statute.
A
Right, so
P3s.
maybe we should add to our definition of, in this section and the other section, the term the state laws now using comprehensive agreement.
But a comprehensive agreement may be one of these things. It may be something.
Does it hurt to add the words comprehensive agreement here to make sure that we've covered everything?
It would hurt, but that's assuming that any comprehensive agreement would be one of these things.
No, what I'm saying is I would list it as a separate, it could not be one of these
It could be
things, it's just a
way
thing of its own.
But if you're, I mean, this is the charter, so that's a statute, and if the statute changes, it's gonna be meaningless.
And also, that's true, and also in the works is an ordinance that is being worked on, and I don't think it's gone to first reading
No, I
yet.
have a draft of it, but.
So, I'm
So,
not
but-
sure if this issue is addressed in that ordinance, in that
I don't know.
proposed ordinance, but there is a proposed ordinance working its way through the system on P3s.
What did you just say just a second ago? I didn't quite catch that.
Sure, the comprehensive language is in the comprehensive agreement, that's from the Florida statutes, the P3 statute.
Okay,
That was
so it's
just-
different than,
And now we're talking about putting those words in the charter, and I'm saying, but if the statute changes, then those words in the charter.
So how do we,
Okay,
okay,
I
so
get
is
you.
it possible that there's a P3 agreement that's not a lease, it's not a license, it's not a concession agreement, it's not a facility use agreement, or other type of agreement for more than one, or other type of use agreement? Is there some type of a P3 agreement that might not fit any one of those things, but that we do want to include in this protection? That's the question. And that's why I was talking about adding the language from the statute, because I want to make sure that if we intend to catch a P3, that we caught it.
As you say, though, it may be another type of use agreement.
But is there a P3 that's not a use agreement?
is that the new, is that the, is that
This section.
Okay, so a typical P3 would be the city has a piece of land, the city needs a new city hall property. I'm not being political at all. New city hall property. It leases the property to at least to a private entity under the condition that the private entity builds a new city hall. Pretty typical, I think. Right, or we have a stadium, right, and we lease the property to whoever's gonna build the stadium, and then and with the condition that they build the stadium, and that, so what would that would be it's a lease, it would be a lease.
so what every one of these P3s seems to have, you know, such nuances with their comprehensive agreement.
There's a subsection in the P3 statute that addresses comprehensive agreement. I will spare you reading the whole thing, but it addresses things like, it says, one of the things is fees, lease payments or service payments. It's long.
Okay, I know what to do with this one. Ask the person who deals with P3s in the city attorney's office whether this 8.21 would cover all P3 transactions. So that if we want to, so that they're subject to this 8.21 limitations, that's the question.
Dwayne.
Whoever would do it. Or if there's some sort of P3 transaction that would not fit within these itemized lists. And also in the section we've also dealt with, just dealing with disposing of, lease of public property, is there some word that should be added into that? Because this is the second time we've used this list. Do you follow me? Okay. So maybe whoever that is, they could get back to us.
I think it's as simple as, maybe as simple as.
Okay, well, just for the purposes of moving on, if you could have them do that, okay? Thank you. Okay, let's move on.
I asked that question, but.
No, I think it was great, that's what you're doing here. It's great.
Good stuff.
Okay.
So, where are we going?
Okay, so now we're on commission direction.
So that's supposed to be 8.21?
Until they get back to us. Right? Okay, so now we're going on to conditional commission direction, yeah?
Yes. So this one is form of government.
Well, let's go, I was looking at this additional condition, exhibit D1, I was looking at, is that one?
I think D1 is the exhibit that the PowerPoint can see.
Pardon?
Yeah, we included, like, D1 is,
Okay, so
D1 is an excerpt.
just for my sake, for clarity, additional city commission directions. So we're, all of the things that we just talked about earlier,
Staff driven.
oh, those are staff driven, okay, and now so when did we discuss, or when did you guys discuss the prior commission direction items? Like, what are those? Because this says additional, so I'm wondering.
Okay, I'll explain that. So this is an excerpt from a memo that Anthony Fajardo did, I'm not sure when it was,
Late last year.
late last year. This is an excerpt from that, and we just left his heading. So I'm
Oh,
not
I see,
sure
Yeah.
okay.
I mean,
where the additional
so,
fits in.
I don't think additional is really the key word there. I wrote that because there have been several discussions with the commission, and then during the joint workshop, they gave
The word
this
additional.
specific,
Oh, I see,
you know, so
okay, gotcha,
additional.
okay,
Yeah, the word additional is misleading.
Okay.
It implies that we have
Other
some
things.
prior thing, but this is commission direction.
okay, so is this the first commission direction? Are these the first items that this board is addressing? Okay, got it,
Yes,
okay, I just wanna keep up with
The
it.
first one was a conflict
Yeah.
chart that I put together, and the next one was observations of a former city attorney. Then we did Article 8, we went over the Article 8 that the board had approved and now reconsidered. So now the next section is what the city commission has directed. And as I say, this is simply an excerpt from Anthony's memo, to list what they were.
Got it,
Okay?
thank you.
So, let's go through it then.
So public outreach, I don't know that we're,
We're bringing that back, so.
yeah,
Okay.
okay,
So
and then form of government.
Yeah, I know that Gabrielle has a PowerPoint for us on the form of government. It's been suggested, I know by the mayor, that he wanted to sort of discuss this. And a bunch of people have raised whether we should be looking at some sort of real change in the form of government. So that's what this topic is.
And by way of background, in October,
Can we go back, additional public outreach, so what public outreach?
Okay, let's bring her up to date on what we've
Yes,
done.
thank you, sorry.
No, we should bring her up to date. Go ahead.
Yeah, so there's been a lot of discussion on what would be suitable public outreach to try and engage the residents of the city. The topic itself, it's a long charter, it's kind of dry, and it's hard to really explain to people. So our strategic communications office, we were doing kind of just the typical thing where we were reaching out to the HOAs and just posting online, nothing really kind of hands-on engaged, but our strategic communications office put together a pretty robust public outreach that kind of matches what we did for the Reimagining City Hall. So the idea is that we would have kind of ongoing one-on-one engagements at various intervals as well as through online portals. There was a survey that was put together and released. There were some concerns with the survey language, so we retracted that. Right now, we've drafted a memo that's gonna go to the city commission that kind of outlines all the things that were brought to this board and discussed on what we can do with public outreach, and give that to the commission for feedback, and then bring the survey questions back to them at a later date, because they wanted to have more input on it. And then in addition to that, I did a presentation at the Council of Fort Lauderdale Civic Associations, kind of as a primer into the charter, and this is what it's about, and kind of get feedback from them on how they would like to be engaged. So we're still trying to put the final touches on that process, but basically what that's gonna look like is more of those types of engagements, a one-on-one presentation with various HOAs through the Council of Fort Lauderdale Civic Associations, and then online versions as well.
Yeah, so, and Mr. Chair, my concern is that I would want to make sure that all neighborhoods have are touched. There are some highly engaged neighborhoods, and those normally participate with the civic association group, and that's great. But there are some that may be defunct or may not be as engaged, and it takes more because the folks are working, to get them out, particularly the Cis Trunk area, And so how, I would be interested in knowing what are we doing to make sure that we're reaching all areas of the community, including those that may not get online and.
Yeah, the last direction at the council meeting, and correct me if I say anything wrong, was that the individual homeowners associations presidents would be the primary point of contact for that, to try to determine what the best form of engagement would be.
Yeah, but some neighborhood associations are not as engaged.
Right.
And so going to the president is not necessarily gonna be a way to reach the residents, so.
Yeah.
And I think maybe even getting the commissioners involved, you know, and making sure, setting up meetings in each district and putting some of the onus on them.
You were sitting here
making-
last time.
Huh?
You were sitting here last time.
Oh, was I?
I'm joking.
Okay, yeah.
Because that was the conference, I asked Richard if I may.
Yeah.
I asked Richard if I may speak on this, because that was my, and I'm saying, the reason why I did like this, because I'm happened to be the second vice chair of the Council for Civic Associations, and it's my purview to make sure that everything is announced properly. I brought it to the chair's attention, Bill Brown, and he appointed each District 1, District 2, District 3, and District 4 representatives to make sure they branch out into their districts, and it's their responsibility to contact all the civic associations within the district and tell them exactly what this program is. His presentation was above and beyond phenomenal. It was very well received. Mary was there, and it was just it was like, finally, common language for the common people about the Charter Revision Board. And it was, just move forward, President move forward. It was just a great thing, exactly. The city was listening tentatively, exactly what was needed and what needs to be happening.
Yeah, and I'll leave it alone, but my final point is that everybody doesn't engage in the traditional ways, and so it may be, you know, the YMCA you need to go to as opposed to, you know,
And we're open to that.
Yeah.
That's always been part of the discussion is how best to engage, not necessarily staying within the limits of what we've done in the past, but what we can do to kind of bring people in and try to get them interested. So I would say that even as we're moving forward under, you know, maybe a formally adopted kind of outreach program, that there's still room for adjustability to kind of capture that, because I think the message has been very clear with the city commission, and as well as the people that are involved in this room and the council civic associations, that they want as much engagement as possible, and the city has a very strong history with that.
How do we customize, the point that's being raised is that different constituencies get reached in different ways. You know, some may be everything on the computer,
Yeah.
some people may get it at the YMCA. How
So
do we
one of the
customize our outreach? How do we get the input so that we can customize our outreach to the different ways that people get information?
Yeah, and so one of the things we've talked about, especially in the Northwest neighborhood where we do have civic associations that are very engaged and others that aren't, that using the religious organizations in the area to kind of help get the message out can be helpful. We've done that in the past and to some success with
So how
that.
does that happen?
Well, we have a list basically of everybody that has kind of been engaged before and, you know, keeping involved in leadership roles in those communities. So we use that to do that outreach, and then if there's any input that we get from anybody that has more knowledge base there, we're happy to do that as well.
I'm wondering whether the commissioners from each of the districts should be provided with the way that we intend to communicate with people in their district, and maybe they have something to add or something that we've left off that we're not aware of, so we can supplement what we're doing.
And there's a couple ways that can happen. So the memo that we're trying to draft and get out, that can be discussed at the city commission meeting and provide feedback that way, and we can have one-on-ones with the individual commissioners and the mayor to get feedback from them from that
Because that could
perspective.
include a list of, let's say, 10 churches or something, and we'd be maybe missing 3 very important churches, like we wouldn't know that, but commissioners maybe.
Yeah.
Yeah.
But yeah, that's a good point, and that's definitely something that we can help facilitate.
Okay.
We anticipate that memo being ready when the commission comes back from their break.
I would hope so, yeah, I wanted it to go out sooner, but
Cause that's kind of like stop the council, cause the council's on break also.
Also too, the commission, I remember, they said they took the survey down,
Oh, yeah.
remember? There was a survey that was gonna be put out there.
It was already out
It was
there.
already out
Approved the
there.
survey,
yeah.
and with the staff prepared a survey, we
Yeah.
approved the survey,
Mhm.
not understanding that the survey needed to be approved, that the commission would want to look at the survey.
Their
before we
preference
put
would
it
have
out.
been to have provide input, but we did get, I would say, pretty good response. I mean, the last time I checked, and this is before we had to pull it down, I think we had 150-ish responses, and for a survey like that, it's
It was good,
It's
it
not
wasn't
bad.
that long.
No, it
Yeah.
wasn't, yeah, there was a QR code they made, which was all our direction, it was, let me tell you something. It was phenomenal what they went and did, and I was really saddened that the commission said, all right, stop.
Where were the responses from primarily, do you know?
I didn't look at it in that way, but it's anonymous if you want it to be anonymous.
Oh, I see.
Some people did put in their name, but most of them, I think, were listed as anonymous, so we don't really have the ability to
I see,
separate
okay.
out.
But I think the overall picture is that we wanna make sure that just going through our normal process, we don't miss people who wanna have input to this process. And we need to customize however we're reaching out to people, to make sure that if they get their information by looking at it on a bulletin board, that we need to make sure they're running. So Anthony, it's on you, buddy.
I can note now.
It is 12. Do we wanna stop? Do we wanna go for another half hour? Because how long is your PowerPoint presentation?
I don't think it's that long. I think the PowerPoint 5 pages.
Do we wanna do that or you wanna stop? Do people have stuff to do? I'm open.
I'd say continue, because once I eat, I get a little sleepy.
Alright.
But
So let's
this,
be real about it.
We're still going over any of this stuff that.
Yeah, we're gonna, actually, we're gonna go strong, we're gonna deal with the second bullet point, that's strong there for you.
Okay,
Right now.
that's something, being one said to me like,
So
get three things.
we'll start
Get all
off
on
with
here.
that, right? Cause I think you were gonna go through a strong there.
Oh, that's right here, that's the next one on the list.
Yeah, maybe we should get lunch and then come back. How about working lunch?
Okay, what about that? What about a working lunch? Oh,
Working
that's a
Well,
great
that's
idea.
good, I'm just saying, you have to keep it moving.
We're doing it by fiat.
Because then you get out earlier.
Okay, well, everybody please get lunch and is what's being broadcast what's on the screen? Sir? Sorry. David? Is what's being broadcast what's on the screen?
Yes.
Or is what's being broadcast pictures of us doing our thing?
Pictures of us, or pictures of you doing your thing.
Okay,
Yeah,
Well, we
the
can-
little square in the
We
bottom.
can get the PowerPoint up,
okay.
once we get set up.
Good, because I just don't think it's so attractive for the public to watch us anymore. Okay, all right. So let's take a break for a couple of minutes, get your lunch and we'll be back.
Well, I'm not now.
You know what I want to do is, because he's not available, that's
Recording stopped.
Thanks, what is the Director of Administration and Strategic Initiatives?
if you'd like to make a comment and you have a mouthful, you raise one hand. So we wait for you. Okay, you ready? Back on the record, please. Did you get your link? Yes.
Recording in progress.
Nope. Waiting for the. Where's your office? You live in a larger firm now, right?
No,
You always do
my
this?
office is in England, but yeah, our, it's always in the same location. It's the blocks, west of the, Avenue.
We're good.
You ready?
We're good, yeah.
Okay. All right, back in session. Everybody's in attendance. Okay, so Gabrielle, you're gonna start with the strong mayor form of government, so the brief amendment?
Yes, oh my goodness.
Okay, go ahead.
Let me just point out that, in 2023, Dr. Peter Cruz from FAU made a presentation to the Charter Revision Board. And so he provided this material, we borrowed it, and we included it in your agenda. So this is not our work. And my colleague, Gabrielle, will make the presentation.
Yes, so, David, are you controlling the screen?
I go to control. Oh, I have it. Sorry.
Okay. So, we also take the notes from the minutes when this presentation is given, so a lot of this is literally his work, so. So we're just regurgitating. Okay, so, in the presentation, Dr. Cruz outlines the different models of government. He has the mayor council form, and that's broken down into 4 different models. So the first one is the weak mayor council form of government. This form of government includes department heads and usually in consultation with the mayor or appointed administrative officer drafts a budget. The mayor typically possesses limited or no veto power. Officially represents the city. The mayor shares oversight with the city, oversight of the city's day-to-day operations with the city council and appointed administrative officer, or both. The mayor may be a member of the city council or the presiding officer of the city council. Under this form of government, the position of mayor is often rotated among various elected officials. The mayor also typically lacks veto power or the ability to hire or fire personnel without the agreement of other city council members. In this form also, there's no strong control, the mayor does not have a strong control over the budget process. Dr. Cruz has suggested in that meeting's minutes that this form of government assists in keeping autocracy at bay. The second form.
Right, so just to distill this. The mayor has some more power than the council manager form of government. And that could be proposing a budget, that could be doing some things, but the mayor is not the chief administrative officer.
Correct, yeah.
I don't know, do you know any governments like this, Brenda?
With the weak mayor, no, I don't.
There, in the chart, the other document you received, I'm pretty sure it outlines which cities in here are weak mayor forms of council. I think there might have been, there's none in Broward County that have a weak, oh, actually, Levy Lake has a weak mayor council. They have 26 residents. The population, at least in 2019.
It's a very small community just to the north of us, kind of surrounded by us.
So the second form was the strong mayor council. This is where The mayor has the power to appoint or dismiss key personnel, has veto power of the council or commission. He or she initiates the budget process and substantially controls the city's budget. There's a single point of accountability and the structured office offers opportunities to build professionalism through the mayor's role and appointment of qualified personnel. The drawbacks of the strong mayor, in Mrs. Dr. Cruz's statement, that the drawbacks of the strong mayor form of government may include undermining professionalism through political and or professional appointments and dismissals. There's also no assurance that a strong mayor has the administrative ability to run a city. This decision is ultimately made by the voters.
And there's only, one in Broward, that being Plantation maybe?
The strong mayor in Broward, there are two. Plantation and Sea Ranch Lakes. Plantation has 90,000 and population of 90,000, 364. Sea Ranch Lakes is 688.
Nadine, Michael, and Mary, how familiar are you with this subject matter?
Come on, put me on the man.
Very familiar?
I'm the man.
So, okay, I just wanted to know the level of detail that we needed.
Yes.
Okay, so then there's the standard mayor council form. This is a hybrid of both weak and strong mayor council. It separates the powers between the mayor and the council and enumerates them in the charter. An example would be if the mayor may initiate the budget, but the council retains significant input into the final version of the budget. Another example would be the mayor has veto power, but the council can override that veto power. This system provides checks and balances to power and attempts to take the best aspects of strong and weak mayor government while mitigating the downsides to the government. Or downsides to this government. Okay. Then there's the chief administrative officer model. This provides for appointment of a chief administrative officer who is professionally trained to oversee the daily operations of the city. This individual serves at the pleasure of the mayor or the council, depending upon variation. The chief administrative officer carries out an administrative duties and oversees the operations on behalf of the mayor, but the CAO is not a city manager. So the mayor will still act as the city manager as well. Okay, you ready?
Okay, so just to contrast a little bit, the city manager, we currently have a council manager form of government, which is the most common form of government. And basically, the council is sort of like a board of directors, and the manager is CEO and operates pursuant to instructions from the policy is set by the council or the commission, and then the manager, typically all the employees of the city, or most of them, there could be variations, are employed by, report to the manager. The council may have their own staff, but that's, and then the civil service and under that all comes under the manager. So the manager is really the COO, chief operating officer. Okay, and then the strongest of the mayors from the government is where the mayor basically ends up being the crinkly potato chip.
I'm sorry.
Right, take a moment,
I got it now.
just like the person in the lady in the movie, or man in the movie in the opera. And they're just, they open up their little cans like so slowly, it goes through like half the show. So the typical strong mayor form of government would be the mayor would serve as the CEO, basically runs the city. A lot of the employees would work directly for the mayor. And there is a hybrid of that where there's a strong mayor plus a manager. And a lot of the employees work for the manager. And there's so many variations of this. Once you get beyond the typical council manager form of government. Are we all familiar with the council manager form of government? So we have, right? Not to cut you short, Gabriella, just to, And then what is the commission form? What is that?
So the commission form, this is one that very few cities are using, but it's one where individually elected officials serve on a small governing board called commission. They exercise both the legislative and the executive power to govern the municipality. Usually there's 5 to 7 members of the commission, and they're elected at large. And each commissioner is administratively responsible for at least one specific aspect or department. So somebody can have fire, somebody can have police, public works, and so on. And one commissioner may be given the title of mayor or chairperson, who just is symbolic.
This is like, I think New York City has this, where they have the parks commissioner and the police commissioner.
Lauderdale Lakes used to have something like that.
Okay. Go ahead.
So, David, will you have a minute? So this is a handout I gave everyone, so they probably gonna have a hard time seeing the chart on the screen. It kind of just breaks it down, just from Florida to city, the different forms of government within Florida. So you'll see 6.5% of council manager, 20% is council weak mayor, 12% is council strong mayor, and then 1% commission, and then 0.5% is a hybrid. And it breaks down by population and the percentage of municipality.
I was interested to see of the 10 largest cities in Florida, what forms of government they have.
10 largest.
Yeah, if we could get that.
What I did, if you look at the second packet, I went through quickly, if I might have missed one or two, but I looked at the cities with more than 100,000 population. 15 of those were council managers and 7 were council strong mayors. There's only 22, at least as of 2019, that had more than 100,000, a population of greater than 100,000, and those were the forms.
But even most of the large cities still have council managers.
So a third had a strong mayor and
Jacksonville has a unique government. I've never.
For a lot of different reasons.
Right, I don't know, maybe you understand, I never quite, I know that they have a unique government.
Yes, the foundation of it is not good.
Oh, okay.
Tampa also has a unique government.
You mean like they have like a hybrid of these?
They have a strong mayor, but everyone's a hybrid. What?
Yeah,
Oh,
Tampa.
Jacksonville.
And I think it was
No,
Castor,
Jackson.
right?
Yeah,
Right?
Betty Castor.
Betty Castor.
No, it's not Betty Castor, it's a different Castor, they're
It's
not
Jane
actually
Castor.
related. Jane
Jane
Castor.
Castor, it's Jane Castor in Tampa, and it's Donna Deegan, I think is up.
Yes, in Jacksonville.
And all of these, I mean, these are not, even the strong mayors are not cookie cutter form of government, they're almost like a Christmas tree. You could hang whatever you wanted, you could say, well, the mayor can't do this, or the mayor can't do that. I mean, it's a free-for-all, really. You could come up with any kind of government that you can imagine.
Well, my thought is that if it ain't broke, don't fix it. But, I guess I need to know the origin of where things are coming from, and if it's just a matter of we're supposed to consider these
Check the
things
box.
and check the box, yeah, great, but
Okay, I've heard from some that there is some interest in discussing strong mayor form of government. Without advocating, I'll tell you, you know this, so I apologize, but basically, people who are looking for a strong mayor of government are looking for an individual person who's responsible, somebody to blame. If you have a manager form of government, things are not going well, you can't unelect the manager. And if the mayor doesn't do a good job, the next time the mayor's up for election, you throw the bum out of office. Gives a central person in terms of negotiation with businesses coming in, for grants, with the federal government, with the state government, gives sort of a figurehead with some power for the government. That's basically the reason, the advocates for the strong mayor of government. The downside people would say is that the government could become less professional. There does, as the professor points out, it could be more politics involved. You could have some erosion of like a civil service, and it could become more buddy system kind of thing. So that's, So I don't know, again, I'm with Bernadette honestly on this. It's sort of like we're shadow boxing because we don't know, I know the mayor wanted to speak about this. So what I think we should do to be respectful to him, and I know he's away on vacation, I think we should push this off, the discussion of this till the mayor can come. And put a specific agenda item for next time, discussion of forms of government. Like the first item or something. So if people wanna come and talk to us about, but I think I'm with you. I'd like to know, like we could talk theoretically about this all day long, but what's the issue? And what are we trying to do? Okay.
I think it should be noted, let's just say that our form of government did change to a strong mayor. The current mayor is not eligible to be mayor again, so it wouldn't.
Actually, you know what? You could write the rules any way you want.
Okay, never mind.
We could write the rules and say that everybody's eligible to be the mayor. Nobody's eligible. No commissioner can be the mayor. You can make whatever you want. You're writing your own. Yeah.
Okay.
Okay.
I didn't think that far.
There's a very, do you ever watch Hager the cartoon? Do you ever see Hager?
Oh, I love that.
Okay, so he's sitting at the head of the table. And somebody's asking him a question, he goes, I don't make the rules here. And then he looks around and he goes, oh yeah, I do make the rules. Okay, so let's move on to the next one. Put this on the agenda for next time, please.
Yeah.
And let's move on to the next one.
So the next item was contribution limits. I think the last meeting, there was discussion about whether we should add contribution limits to the charter. Currently, there's an ordinance 12-4 that talks about campaign contribution limits. And they currently capped at $1,000, which is in accordance with the Florida statute. The statute does preempt municipalities from enacting or adopting legislation that would provide for different contribution limits. So any existing or future limitation or restriction enacted or adopted by a municipality would be void.
So you're saying there's nothing that we can do here?
Yes, I did want to point out that I did a little research on different municipalities that have limits. Miami-Dade has, they more or less refer to the statute, but the city of Hollywood has it in the charter. And they have it capped at 5 people. So
But you're saying that the state law prohibits, this area is preempted?
yes, so it's void anyway.
Yeah, it was passed, I think, like 3 years ago, 3 to 4 years ago.
So we can't do anything, yeah? Move on, right? Okay, next.
I think the next was P3. No, P3 special.
Oh, P3. So, excuse me. I'll take up the discussion, but I really don't know what to discuss except that in 2024, the legislature amended the P3 statute to expand the procurement procedures. So now there are 3 procedures that I can go through. I'm not really sure, maybe Anthony can help, I'm not really sure what to address.
Do you know what they wanted us to, do you have an idea what they?
I really don't. There wasn't a lot of clarification on this. I think there may have been, I don't know if it was a misunderstanding that there was something in the charter currently about P3 or if they wanted to add language to the charter.
I'm gonna suggest that the idea of this shadow boxing is really not productive when we don't really, I think we should ask them a question. And I think we should ask them a question and say, we see that you want us to look at these P3 things, please tell us what you'd like us to look at. And let them tell us. Or let them have a discussion.
I think that Dwayne has, or I think you were looking at that,
There's an
and he wants
ordinance in
to
the works.
present it at the next commission
It
meeting.
was presented, I think, on the June 30th meeting.
Oh, it was?
That's what it said.
So good, man, I didn't
But
want
not
that.
for adoption, right? It wasn't a reading.
Not for reading, it was presented as a discussion.
Alright,
So
so
that's in the works.
in light of the proposed ordinance, what is it that you want us to look at? I mean, it just doesn't make a lot of sense for us to try to guess. They may have some things they want us to look at, which I'm very happy to look at, but I don't know what they are. Yeah? You agree?
I agree, it was a
Agreed.
rich discussion when they brought it up.
Anybody dying to talk about this?
Not really.
There wasn't a lot of discussion.
Can you send it out to the board, the P3 ordinance proposal?
It's a good idea.
Okay.
Then you read it and explain it to us, cause it's when that ordinance language is, I don't know, I have a harder time with that than anything else.
Alright,
Can we
next,
do that by motion or
What?
by communication to the committee?
Yeah, and I don't think we wanna put P3 language in the charter. Yeah, it doesn't really belong in the charter.
I agree. Okay, Anthony, you know what to ask them, right? Sorry, you know what to ask the commission. right?
Yeah, I'll figure it out.
We'll do it. I know, we know what to do.
I'll figure it out.
Okay, we're moving, we're informal here. Until it doesn't work, then we'll do something else. Okay. Election cycles.
Yeah, so election cycles, if we understand the request was to look at, maybe doing a staggered election. So, did some research on different, cities that have staggered elections. Sunrise has it, Miramar, and Hollywood, were a couple that I pulled. So I think there was a question on how did they go about creating a
But
staggered.
let's stop for a second. Okay, so I will say that I think staggered elections are great. I mean, they are difficult to implement in the beginning because somebody's ox is getting bored or somebody's getting additional time or, but I think that's my, what does the board think about staggered elections?
I think that would be a great thing because, you know, we just recently had several brand new commissioners. And, you know, getting up to speed, I actually heard the commissioner, McKenzie one time say, you have to be commissioner for 4 years and then you understand what's going on the next 4 years. It's a big learning curve and I think to have everybody be on that curve at once is not good for the city.
Michael?
In speaking to other cities, where they stagger elections such as, to be very frank, it's what manners, and then, speaking to some of the commissioners there, and works.
What, staggered?
Staggered, it works, yeah. Because it's the populace of the city is not held at bay. Like, you can have a wipeout, you know, and you can lose 3 commissioners or whatever. So it's everything to me is agenda for the residents.
Nadine, Bernadette?
Taxpayers, sorry.
I don't really have an opinion one way or the other. I think the voters have, wasn't it on the ballot that we would keep our election in March?
No,
November. November, yeah, it was changed to November, it was changed to November, that's what.
The timing of the election
Yeah,
changed.
it was changed to November, yeah,
Terms.
Yeah, I'm not aware that the idea of staggering.
but not the stagger issue. I don't know if I have anything, I would wanna hear more, I mean, logically, if I'm just talking out loud, it makes sense because you don't have everybody coming in at one time and, you know, people will have, you'll have some legacy experience there, people with institutional knowledge, so forth, but.
So you have an open mind about it.
Yeah.
Okay, what about Nadine?
I kind of have an open mind about it too, because I've seen it in both situations where you have capacity that you've spent in investing, an individual sitting there, and they have the experience, and so now here's another cycle of new people, or not necessarily new people, but newly elected officials to come through. And then sometimes I've seen where they all just need to go. I mean, you know, we don't wanna say it for what it's worth, but the truth is, they need to pack up and be gone. So I can be either way on it. It's just that we have to then, I think we need to go back and look at the history of this city and determine what has been best at least over the last 50 years to determine whether what we have works.
I don't think I'm aware of.
No, I don't think we've ever had it here. So that's why I say sometimes you have to look at what were some of the complications that made it us now look differently, and what are some of the things that we can foresee, that we can possibly forecast that may be some issues in making these adjustments over the next 15 years.
Okay,
So I say, let's study it.
okay, so we have two people at least that would like more information, would like to discuss it more, would like to think about it more. What type of information can we provide?
Well, there's a note here that says that the CRB may wish to hold off on addressing this issue until outreach has been completed and comments public have been considered. So, that doesn't sound like a bad.
Okay. So maybe that's a solution, right, for the moment, which is basically, it's gonna be included in the outreach, some specific clear language to explain to people what this is, and see what the public has to say, get some input on that, and then deal with the input, yeah. I think it's also the same thing probably with the strong fair form of government too, get some input from the public to see where they feel like a change is warranted or necessary. Okay, I think that's a good way, I think it's a good way to put this on hold for a little bit.
Was that on the survey? I'm trying to remember what was on that survey that got pulled.
I have to go back and look.
Okay, I'm glad to hear you don't remember either, but I think that was on there.
Rich, it was there.
It was
I thought
on
it
there.
was, but I
It was
couldn't
there,
get it.
and that's where at the council, full of civic associations, you're like, wow, you're finally addressing this.
Yeah, because we
It's a lot
had that doctor come and talk to us.
Yeah.
Yeah. That's right.
And the last one, the ballot referendum, we've taken care of this, we approved it today, the whole referendum procedure. Right?
Yeah.
Good. Okay. All right, now we are, we're gonna skip B because the human resources people can't be here, right?
Yes.
Okay. B.
Okay.
On page 2B, okay. Now, let's go through the remainder of section 8. In terms of the sections that we've not discussed, right? Okay, so where are those? Oh, wait a minute, was there any more, Gabriel, that you wanted to go through on your page? That was it? Sorry. So, thank you. I like the color.
So that is exhibit F. And it's just a compilation of the sections that you have not addressed.
And you'll let us know if they relate to. So this is the existing language, all of it. It's a different type case.
Yeah, Anthony can better.
Yeah, Anthony, you must be young, because
Exhibit F.
these are small, very small. Okay. All right,
I'll make a minute next time.
all right.
So I'll start with 8.03, in as our common law, private like. The city can give land to the state or county for roads and use public funds or trade property for that purpose. This only applies to conveyances and expenditures for public roads within the city limits.
So here's my question. Why is this different than the section we've already discussed regarding conveying land? We haven't discussed acquiring, but what about conveying? Why is this not just covered under the section we just dealt with, conveying land to public bodies?
It would be, but I believe it encompasses acquiring right of way for the purpose of conveying it.
So, I'm confused, something you would purchase.
Like,
I understand what a right of way is, you would purchase it because it would be advantageous.
Let's
For land we already
say
have.
the state comes to us and said, we're gonna put a brand new road in this particular area, but we don't have the land.
Yeah.
We don't have the money to purchase the land. So city, if you can purchase the land for us and give it to us, then we'll construct the road, something like that.
It was acquired by the city for the purpose of conveying it.
Right. So it's a flip, it's a flip.
That doesn't happen.
Well, it's okay. I mean, it could be very wonderful. You know, for instance, if the state wants to put it, as I said, if the state wants to put in a road, that would be really great. And the state doesn't have they have money to construct the road, but doesn't have money to buy the land. The city could acquire the land, and then the state would build the road, and that's what the city wants.
And note the sentence that this power is in addition to authority elsewhere granted and is not limited or restricted by 8.02.
Okay,
So
so
this is in addition.
just as foundation, the public property part of this goes under which bucket of, is it something that we're being asked to consider? Is it something staff is recommending? Is it existing?
At the last meeting, we were asked to go through the rest of the rest of Article 8. This is the rest of Article 8, which the board has not addressed.
Okay, and so I don't see any underlines, so this is the existing language.
Right.
Correct, okay,
So
I just wanted to make sure.
We haven't done it.
Okay, just wanted to make sure.
There was an agenda item from the prior board
Uh-huh.
of a whole thing dealing with public property.
Okay.
That's all in A. For the purposes of completeness, I felt like we've dealt with certain areas, we should go through the rest of 8 and just be done with
Okay,
public property.
got
That's Rick's.
So there's been no direction to cross out or
Okay,
add.
has there been any issue presented that it's difficult from administration or legal or anything that you're aware of that deals with this provision?
I'm not sure I can comment on, well, by EMR has been.
Well, but the entire article or just this?
That section.
That I've never heard.
Yeah, I'm not sure how to answer.
In 20 years, I've never heard anyone even mention that section.
Okay.
Well, but it's not conveying.
That's more of a,
There's
What do you call that?
specific language with by EMR, there's specific language for airport property.
Yeah.
what do you call that project that PMR is? It's on a P3, it's a, what do you call that?
It's a lease agreement.
PDD or something?
It's a lease, isn't it?
It's a lease.
Yes.
It's just a plain lease.
It's more than that.
CDD was created.
Yeah.
Oh,
Development was created.
yeah,
That was for the air rights or something.
but that was for a specific issue that came after the lease agreement had been
Okay, so
drafted,
that's
that
not
was an
this,
update.
okay.
Okay, I don't know if this is where Bernardo was going, but nobody's raised any issues about this. And if Anthony hasn't heard any problem about it in 20 years, I say we move on.
Okay.
Any objection?
Or somebody come up with.
I'm talking about 8.3. Okay. Leases for not more than a year. We've covered this, have we not?
Other,
No, I don't think you dealt with leases for not more than a year. Is they?
Oh, for not more than a year.
oh,
Yeah, I don't,
But we have covered it.
I don't,
We have covered it.
I thought it was
says-
like for
it
less
just
than a year.
It requires 3 votes and that's it. Nice to know you. See you in September.
In the discussion before lunch?
Yeah, those 4 different areas, right?
so does this section become superfluous?
That's the question, whether we would have just dealt with it.
Yeah, was it?
Eight oh
nine or 8.21?
it was 809.
It was 809.
I make a motion to make Mary the vice chair. Second, all in favor, I'm going to the rest, quick back. Mary, you're in.
Oh, geez.
Why did we
You're
just
not kidding, I thought you were making that up.
No, just wait till you come back. I mean, this is pretty important.
Yeah, we'll wait for you to come back. As vice chair, we are gonna pause for about
Recording in progress.
Do we need 8.05?
So let me suggest that in your discussion about 8.29, there was the inference of leases up to a year or less than a year, that they would be approved by a city.
Pardon?
Thank you.
Thank you. What page, where is it? Please.
8.09 is on page 7 of exhibit C. So there was an inference.
Hold on. Cities empowered to enter into lease agreements, not an inference, right?
No, there's an inference regarding leases up to a year that they would be approved by a simple majority.
Because any vote that's not specified is going to be by a majority.
Okay, so this specifies, it gives it some more specificity, and it also mentions recreational facilities, golf courses, which I guess the city doesn't have at the moment, tennis courts. It also talks about granting concessions for up to 1 year by majority. So I don't think it's superfluous. It also talks about leases not exceeding a year to civic or charitable organizations, public nonprofit corporations, and like organizations.
Tell me what this covers. Okay, under the section that we already approved, the city has the right to lease property by whatever it's called, concessions, very broad, right? For less than a year, correct? By 3 votes.
In
Correct?
8.09,
No, in the first section.
in 8.05,
No, he's talking about 8.09.
The first one we discussed today.
8.09.
8.09, right? Very broad, we have the ability, the city can lease it, concessions, all that, less than a year with 3 votes. What does this add to that? They can, and by the way, there's no limitation on the purpose of those leases. It could be for any of these things or none of these things, or things that we haven't even thought about.
So what it adds is, if you look at the first sentence, upon a majority vote of the city commission, we discussed, or by or through any board, commission, officer, manager, or city manager designated by ordinance to do so. There is an ordinance that I drafted many years ago, around 2-63 or 64, something like that, which talks about the manager's authority to enter into leases up to a year. I don't think it's in 2, it's there's an ordinance in the code. And I remember putting that together because of this section which authorizes it, but there was no mechanism at the time. So the ordinance, as provided here, gave the manager that authority. And it has been used, is my
so-
understanding. And that's not an 8.09.
Good.
So why can't this language be placed there in that section?
It could be, it'll just make it longer.
I had another question, which is, since the city can do whatever it wants unless it's prohibited, if the city commission has the ability to lease property for less than a year, why could it not pass an ordinance saying we delegate this authority to the manager?
Which they've done.
Which they've done, so why do you even need anything about
But it was
Well, that's a
pursuant
good
to
point.
this section.
Well, why do you need
Oh, I
it?
see.
Why do you
Well,
need
you don't, if this section goes away, you don't need it.
I can probably find it though.
No, you don't need to. We're assuming that you did it, that it's there, but I'm just saying, I don't think, why don't you do this? I don't think you need this section. I think it's, why don't you take a look at it with your whoever, if you feel like there's a need for this section, come back and tell us, otherwise, I don't see it.
Now, the only issue is, you'd have to go back and revisit the 8.09 language that we were dealing with earlier that talked about a majority vote, because if the manager now has some discretionary authority based on ordinance, then that's going to need to be adjusted.
Say it again.
You're going to have to go back to 8.09 and adjust that language because you know.
In the existing ordinance.
Right, in the existing charter language that we just made changes to.
Yeah.
Because now this makes it where if we want to give the authority to the city manager, you don't need 3 votes. You can say unless, except for, or just some adjustment that would address the city manager having the authority for leases under a year.
So in light of this language, at the time, I didn't think it could be done by resolution because it says by ordinance, and that's why we did an ordinance to allow it. Now, if you were to delete this section or repeal this section, that authority quite possibly could be delegated or could be authorized by resolution.
Resolution or the city, well, you can still do it with the city manager, to still allow for the city manager.
Right, but what required the ordinance is that it was here.
Right, but if this goes away, and I agree with, I think it might have been Richard, I don't know that you necessarily need this section.
Mike, you may have looked at this way more recently than I have.
No, I'm just looking at it now.
No, I'm talking about the law.
Oh.
I think that the city commission can delegate almost any authority that it has as long as there are criteria, right? That was 100 years ago when I looked at this.
Yeah, and sometimes those guardrails are actually in the enacted language in the charter, like it will say, this is what the city manager can do, and that might, and I can pull it up.
There is a section 4.10B, I believe it is, where it says that pretty much all instruments, contracts, whatever instruments have to be executed by the mayor, manager, attested to by the clerk, and approved by the city attorney, unless there's a resolution or ordinance that says otherwise, in which case it can be executed as that resolution or ordinance says. So that's why I said, because of this language, it had to be by ordinance.
Right.
But without it,
right.
But on the other hand, I'm not sure what you really accomplished by deleting it either.
Because we're trying to get junk out of it. Because
Exactly.
we're trying to get from this to this, there's no reason to have that.
This charter is way too long.
Yes, she and I are on the same 100 pages, yeah. I think that we should make a note, when we talk about the city manager's authority, they should have the authority to enter into leases up to 1 year with the authority of the city commission, and that's where it should be. We don't need to do the other one, because they already have the authority, give the authority. So, if you could make a note, when we get back to that section, otherwise I don't really see any reason to do this. And this is so unusual, leases at the Bahia Mart, to have this kind of thing in a charter. Why don't you go through what this is?
8.06, leases for Bahia Mart property may be negotiated by the city commission without bidding, except that no such lease shall be for an initial term longer than 15 years. Extensions may also be negotiated, except that no extension shall be for an additional term longer than 15 years.
So they just did a deal for Bahia Mart, right?
Yes, sir.
The last few years, yeah.
That's the year.
And of course, this section is notwithstanding the limitations in 8.05.
This implies that there's a requirement that if you're gonna lease city property, you have to bid it out. Where is that requirement? Because it says, without the necessity of public bid, which implies that under other circumstances, you do have to have a public bid.
Oh, don't you?
No. Not that I'm aware of.
Okay.
Unless it's required in the charter.
Leasing.
As you've recommended amendment of 8.09, I agree with you. The way the charter is currently written, I believe there is bidding and competition for it.
There is.
It was all crossed out, I believe, in 8.09.
I mean, I think the city commission is smart enough to use whatever the appropriate procedure is that they.
I believe it was, there's a lot of 8.09 that I believe in your recommendation was.
I'm out of 809, 09. time.
So 8.04, that's the case for sale.
So you think there was a provision in prior 8.09 that required leases to be bid?
I'm looking at,
Leases to be bid, that sounds unusual.
You know, like if you're gonna
Yeah,
lease city property, that
yeah,
you have to basically put out for public.
yeah, it is. It's all crossed out, but yes, in 8.09, there was language about shall be offered upon competitive conditions for lease as desired and a notice shall be published, see issues. Then the resolution accepting the bid shall require the preparation, so yes, there is existing language
So
about bidding.
do you think that we, without all that stuff, that we properly protected? I mean, they can't lease property for more than a year without 4 votes. And I assume that some people feel like there should be some public bidding procedure, they won't vote for it until they get the procedure they want. But under other circumstances, maybe they just want to lease the property out. What do you think about public bidding for lease?
I think that gives the city commission flexibility, and that would be a good thing. We shouldn't strap them through the charter.
Okay, so why do we, if there's no public bidding for leases, why do we need this provision?
Again, we haven't touched this provision yet, and the way the charter is currently written, there is, we've crossed it out.
No, I'm saying in light of what we're doing, why do we need this provision? Okay, I want to make sure we haven't screwed up something you guys learned at. Again, I would check with your real estate attorney, whoever did the BLMR deal, and make sure they didn't rely on some provision here that we're not seeing. And that by eliminating the section, we're not messing something up.
Yeah, it would worry me to do that,
I wouldn't, you know,
because
Any
this was
leases?
actually approved by not this commission, but the commission before.
or the BLMR.
Yeah, but not even the commission before that, I'm not even really sure.
No,
Yeah, but the only issue we're talking about right now is the public bidding part of it, right? So if that's the case and it doesn't have to be bid, and I don't think it was.
I can get history on the BMR property, but when it was acquired, I don't remember when, maybe Anthony knows, but it was different type of land in the city, I believe, expected to earn revenue on the BMR property. I don't know, I don't recall the history of how it was acquired or why it was acquired. But it was a moneymaker for the city, I believe, at the beginning. I think that was the intent. So that may be why it's handled differently.
Well,
But I'm speculating.
here's the question. I want to make sure by eliminating this provision that we're not unintentionally interfering with whatever transaction they did on the BLMR.
And that was contractual, so it's not like anything that happens now would be impacted. I mean,
Well, but it was pursuant to this because it was the 50-year issue.
You can't impair a contract.
Right, but I mean, but that, they've already signed it,
It's all
it's all done
But this also addressed extensions.
in 50 years or 48 years or whatever it was.
But listen, check with whoever did, yes.
There was a last meeting, I recall, and I looked in the minutes and it wasn't there. I just had Jim Kincannon speaking, but there was a lady here called Marilyn Merrill, and she made a comment on this.
Oh, was that here?
Right there,
I mean, was it the charter? This, okay, I do remember that.
yeah.
I was thinking it was a council meeting.
What did she say?
No, she was here, she was sitting right next to Jen.
Yeah.
What was she talking about?
She was talking about this specific item.
This
Yeah.
provision?
Yeah.
Oh.
Yeah.
But what was she in favor of it and?
No, she wasn't in favor of this.
That's at Lauderdale tomorrow, and they were very opposed to the
Yeah,
project.
She may have been talking about the 50-year limitation in the other
I think that's what she was
section,
talking about.
8.09, not.
Yeah.
And
I think she was talking about the length of the term.
Right, yeah,
So not this
and she
specific
made a comment
section,
and then she dashed.
not this specific section, but it was in the context of by EMR via 8.09, I believe. But regardless, you're right.
Is it not odd that an actual property name would be in
Totally
the,
odd. totally odd.
I would-
It would be more typical if you had like the airport, that would be,
Yeah.
like, there's a section of the Dade County Code dealing with the airport, or Opelika Airport. But to have a specific piece of property, Old McDonald's Farm, it's very,
It's just, I find it alarming.
it's interesting.
It is.
I find it alarming.
So let's do two things, because I don't want Mary to be alarmed. One, check with the
Too late.
whoever's handling the EMR transaction to make sure we're not messing something up. Number two, let's see if we can figure out why this provision was originally put into the charter, because I don't want Mary to be alarmed.
Do you
What- I mean,
see,
what's-
do you see what year this was put in, by any chance, do you see?
Does your code not have a historical?
Yeah, I don't see that on the
On
bottom of this,
most
Well, I see it
municipal
right
codes,
here,
it
but I think-
shows-
but I'm not sure if that relates to that section, it just says created 2023, like was this a part of what was created in 2023?
Does anybody have municipal code open?
I'm looking.
Usually on the bottom of every section, it would say
When it was.
the ordinance amending it.
Not for every section of the charter. I'm looking for some.
Well, that's another footnote for me. I think that municipal code should be instructed to start keeping track of when this thing is amended, because I think it's very useful. Good. Gabrielle, could you make a note of that as a footnote, because I think it's very nice to have those. Usually in municipal code, Nadine, they'll say this section, then underneath it'll say amended ordinance blah blah blah, 2021, ordinance blah blah, so that you can go back and pick up the legislative history more easily. I don't know why you're saying.
And now you can click on it in most of the community code
Pop up.
sections, you can, and it will give you the history, you can click on every year changed and,
We have that for code sections.
oh,
Oh,
okay.
you don't have for the charter? Well, they should.
It's in part of it, not all of it. Like section 8-8.21 has ordinance
Because that
listed,
one
so.
was amended in 2004.
Right, but I think what's happened is they haven't gone backwards, they just started doing it as a.
Okay. David, are you dealing with municipal code on this stuff? Who
Not
does?
particular with managing Unicode. It's mostly the attorney's office that reviews everything that goes in, but that's something that we can bring up. So
Okay,
what
somebody.
we would have to do to go back and
Somebody's a liaison with Municipal Code Corporation.
Yeah.
And figure out why we don't have all these historical references in our charter.
Okay, so when you press compare versions.
Yeah.
It has, and I'm not gonna compare it, but it does have supplements going back to 2011 only. Now, I'm not sure if this was in place prior to 2011, but it goes back to December of 2011 under the supplements related to this section.
It could just be the property itself, because it's always been known as Bahia-Mar.
Right.
I can see that
Because
here.
if we had the ordinance, we could look at the ordinance and we go back to the minutes and see what people were talking about when they enacted this section.
But something else that will help is I recall when the negotiations with Bahia Mar were done around 2014, 15, around that time. There was a presentation to the City Commission with the history, and that's where I'm getting my vague recollection of what the history was. We can try to go back and try to find that. I think there's a whole history somewhere.
It is.
There is.
It is Fort Lauderdale, that's what, it is the army base of what Fort Lauderdale is named after, that was that mine. But it's been a part of Fort Lauderdale history for a long time. So if you guys go back to at least 1939, 1947, when they acquired it, you will be able to probably find it.
So we know what we're doing on this, yes?
I'm not gonna
Okay.
touch that.
8.07. Did we cover this already?
No.
Entities of governmental entities or agencies for governmental purposes, didn't we cover this?
Not this section.
No, but I mean, didn't we cover this subject matter in our prior section?
Yes, because we added at least two. I don't think it was in the,
What sec, where would that we did?
that would be 8.02 or 4. Two of them. So, that would be 8.02, and I believe.
Authorizing power of the sale, lease, otherwise conveyed, okay, so we covered this.
Right, but that's new, I don't believe it
I know, but
includes.
we're trying to move ahead, understanding what we've already done. So have we taken care of this? This is a 50-year time restriction. I don't believe.
Yeah, in 8.02, we added the lease, so now it may be.
And there's no 50, I don't feel like you need a 50-year limitation when you're dealing with the government.
I think that's in that
In that section.
8.02.
I don't think there's no time.
Because you were talking about sale.
Right. So there, you did add lease to 8.02, but no time limit.
Does anybody feel like there needs to be a time limitation when you're leasing to another governmental entity? I do not.
I feel like 50 years is an eternity anyway, so.
Anybody feel like we need a limitation? Maybe leasing to another government?
Unless there's something in the ordinance that respects the culture of the land and what it was done, like we're looking at the Hill right now. And it has been a part of Fort Lauderdale's community, honestly, even before, right after it became a city. So I'm just saying is that time restrictions may give for the opportunity to look at the history. And just a pause to say, let's try to respect what's there. Because if you give them no restrictions, then it's the possibility of 5 generations coming down the line and see no importance for it.
And you've really sold it. You've sold it. If there's no restriction, you might as well have just sold it.
But the city's always had the ability to sell land to a governmental entity. Always.
Some governmental entity.
Because all we're talking about is governmental.
Yeah.
They've always had the ability to do that, so
Well, I don't know then, yeah.
if you're saying that you do it for too long, it's like selling, well, they have the ability to sell it if they want to.
So the other distinction is.
But this is only dealing with leases though.
Yeah.
Yeah.
Mary was saying if you make the lease for too long, it's like selling it, and I said, yeah, but they already have the ability to sell it.
Well then, there's no reason for them to have to buy it if the lease is like forever.
Right.
I don't know, you know,
Well, maybe we just leave it alone.
yeah.
Another distinction is in 8.02, it's for a public purpose which was defined. And in 8.07, it says governmental purposes. And
Me, I would eliminate it. I don't think it adds anything to it. I'm not worried about leasing to a government for 75 years. That's what the city wants to do. But what is the,
Yeah,
what do they say? What is the,
I see your point.
what is the will of the body? What do you say, Michael? Sorry, it's okay. Do you think we need this 50-year limitation on leasing government property, or are you okay with leasing to a government for longer?
No, not in the first part, I'm not hands on.
What do you, Nadine, what do you think?
I mean, again, after 50 years,
Who
you
cares?
kind of have given it to them.
Alright, so also the reason for this, as distinguished from the other section, is that the other section currently requires the bidding, and this, to your point, maybe somewhat superfluous because this section provides for it without competitive bidding, but you've eliminated that and.
Anyway.
Yeah, you eliminated it anyway.
All right, so unless there's some objection, we're gonna eliminate this section. Yeah? All in favor? All right. Michael made the motion and Nadine seconded.
Sorry, can you get
Michael, very strongly.
Thank you.
All right. Okay, leases of public parking spaces.
City can lease parking spaces in city-owned garages to private persons or entities for up to 50 years without bidding.
Okay, so this, if assuming that you eliminate this section, they would be able to lease it for 1 year with 3 votes, 10 years with 4 votes. And after 10 years, how many votes do we need? Unanimous? Pardon?
It's been going.
What?
Forever.
What is it?
All the abuse.
So let me throw.
Hold on, under the prior, what we did previously, if a parking space is just a piece of city property, less than a year takes 3 votes, right? Between 1 year and 10 years, takes 4 votes with some rigmarole. And then more than 10 years, it takes 4 votes with more rigmarole. So if the parking spaces are just property, are you comfortable with that scenario for parking spaces?
Can I throw something else out there? We're talking about parking spaces. So it could be in a multi-level garage, it could be in different places, in parking facilities. So this is a situation where perhaps it shouldn't be a lease, but rather a license, because it's really
We're
allowing.
treating leases and licenses all the same.
But this really, it wouldn't be a lease because it's allowing the use of a space. So if you call it a lease, would you have to go through the eviction process to get a car out of there? I just don't know that it's correct to even call it a lease.
Okay.
But the point, as Richard just made, is that we have another section where we're treating them all the same, licenses, leases.
In terms of the vote. And if they decide to do a license, then you wouldn't have to do an eviction. But in terms of the procedure for entering into it, not defining what's gonna be in the actual document, that could be different, Paul, to your point. You might enter into a different type of document for a parking space than for a vacant lot. But the procedure is, I think it's covered.
So Richard, so you're saying that here on leasing for parking spaces and public facilities and parking facilities, the parking percent, because there, let me come out of context. There's a problem with one of the companies that the city is given to, because I know people have went to the city of Fort Lauderdale at the 2900, 290, the mobile. Where you get the licenses and everything else that.
Motor vehicles?
Motor vehicles, well, yeah, no, it's on Third Avenue, it's 290 Third Avenue, you know, there's a facility downstairs where you pay your parking ticket, right? And I've witnessed there where, there are outside agencies that are not compliant, that are charging enormous crazy fees and everything else. So where I'm going with this is that if the city is renting out to these people here, there should be a restriction if they're a good client or not, which.
Well, I think that would be covered in the lease agreement. In other words, if they're allowing, if they've basically contracted out, is that what you're saying? They've contracted out the letting of city parking spaces to a private company, that's what they're doing?
Yeah, and it should be on a year-to-year basis, not.
Well, there's no problem with that. City commission could do that. But let's say they have a great operator and they wanna do 5 years. What are you saying, Michael? We should limit the leasing of city parking spaces?
Yeah, if they're a poor client or if they're not a good company that's really doing, the responsibility and charging astronomical fees of parking there. $90 a ticket, $95 a ticket. And speaking about this, because it was on, next door, it was all over the place, and then I happened to walk in on the area of which I happened to go to TAM, and I was waiting for it, and I was standing in the lobby, and I heard all these comments going on. They said, "Who is this company here that's allowing the city doing this?" And so that's why I'm just giving you feedback.
So I have his permission, but present with us is Assistant City Manager Ben Rogers and former Director of TAM, who may have something to add.
And before you do that, if you can just add in, because this talks about just non-public purposes only, and that's what this leasing provision is about in the charter. And if you can address that with your comments.
Perfect, good afternoon, everyone, Ben Rogers, the Assistant City Manager. As Paul said, I used to oversee the transportation mobility department and which includes parking services. I think, because I walked in mid-conversation, that the intent or the conversation is focused on parking leases and the duration of time. I do think there's probably some confusion on it because we have different scenarios or different relationships with different folks. But I think the language that you're talking about is focused on things like, we have a long-term parking agreement with the 110 corporate building right behind you, 110 East Broward, for them to be able to have 700 parking spaces in the Riverwalk parking garage. We have an air rights agreement with 1 East Broward where they park in the City Hall garage. So there's a lot of, I shouldn't say a lot, there's a few contracts or agreements that we have in place that are long-term and it's supporting the, I would say, the economic development, the commercial enterprise of the downtown. We don't have any properties that we lease out and turn over the keys to for operation other than the parking area at Inter Miami Stadium. Other than that, I think the references that Michael was talking about, those are privately owned parking lots where people are hiring what are known as predatory parking companies to go out and write high tickets based off of license plate readers and don't really give people the opportunity of the appeal process as the city would. So if there's specific questions, I'm happy to answer them, but I do think there's just a sliding scale of what we have out there right now.
Yeah, I through the chair, I get what you're saying now, and how long approximately are those leases that you have, like with the 110?
I think they were both 50 years.
Yeah.
I think the air rights agreement here at City Hall maybe has less than 10 to go. I think the air rights or the parking agreement for 110 building, I think expires in 2045 or 2046.
Yeah. So I don't see any reason to really mess with this, and it talks about non-public purposes. I mean, that's really what I'm zeroing in on.
My question is, thinking about this, how can a city do anything for a non-public purpose?
Well, I mean, it's not a public purpose if we're leasing at some cost that the city is getting revenue from the 110 place or whatever. That's a non-public purpose. That's
Or
not
maybe
helping.
public
That's
purpose
helping
is
that
making
business.
money.
Yeah. Well, that could be.
The city has proprietary, that would capacity account, that's what I say, to make money.
Right.
Yeah. And he's saying that could be a public purpose.
What I'm saying
But
is anytime-
so the word non-public, maybe the word non-public shouldn't be in it, but my I guess my point is, I don't know that, you know, if it's working, things are working under this, everybody understands, you know, I don't know that we need to mess with it, because there may be something else that we don't know that we're not capturing, and by taking it out,
Lease
we
or
don't have that
concession.
extra.
It's a lease or
surprise.
concession, I don't need a concession, I don't know that that's a verb, but by negotiation without competitive means of private or for non-public purposes, parking spaces and parking facilities owned by the city. Parking spaces and parking facilities owned by the city or operated so I don't really have a problem with this, I don't think it's necessary, but there's no problem with this, right?
No, that's my
You're
knowledge.
doing business fine, right? Alright, let's leave it alone. Okay, how about the airport? Do we need someone from the airport to talk to us about this?
I can tell you a little about it.
I mean, seems to me that we want somebody, because I'm totally, this is not basic charter law, it's nothing I've ever even.
Yeah, and there's federal law involved, there's FAA, there are grants, restrictions.
Okay, so
there's
for
a lot
next time,
to it.
not tomorrow, for our next meeting, we need someone from the airport to come, whoever's knowledgeable about this, to come and explain to us what this is.
Can I just ask, I guess just a question of how we're proceeding? Is our goal to touch and read and review every piece of this, irrespective of whether issues have come up around the certain charter provisions or not?
This may be a little bit of my craziness, but I felt like since we dealt with, if we were only gonna be dealing with, I think you asked a very good question. If we're only dealing with issues that have been raised, we're done.
And I bring it up because, 2 days of this is a lot. right?
Yeah.
Okay, for people who work like me, this is a lot. So, and I can see that some of it is not based on, something the commission wants us to review specifically, or, something that we know that there's an issue with. And so I don't know how many more, section 8s we have in the charter,
Well,
this extensive
I
charter.
understand exactly
And
what
I'm
you're
wondering,
saying,
I just don't know that,
what our charge is.
and it may not be a good use of our time unless certain things have come up in this, so I
was told, and I've got appointed to this, that they want us to go through the charter, modernize it, get rid of junk that wasn't there, and to really do a full charter review.
This new commission said that, or was it the previous commission?
Nobody has said that as a commission. It's commissioners speaking to me and saying our charter is old and needs to be gone through and blah, 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 and all that kind of thing.
All right.
So I don't want to and so I've been proceeding, I did from the very beginning to think that we should just go through the charter and clean it up and be done with it, like you and I would do.
Right.
We were hired.
Yeah, no, I got it. I'm just wondering
But-
But
listen, we've had no specific direction that way. Anthony, maybe you have some input on this.
No, I think what you said is correct. I think another way of looking at it though is that a lot of the comments that you're seeing from the members of the public regarding disposition of property are related to specific issues that have come up. And I think another way of examining this is trying to anticipate what might come up later. So going through each section is probably a prudent thing to do. Because a lot of it's been driven by those public comments and then those generalized statements you saw from the city commission. But I have heard them say a couple of times, just in random conversations, that we should be looking at the whole thing.
So,
well, if that's the case, then it ought not be that the city attorney's office would be charged with doing these individual questions. It would probably just be, as you see sometimes when charters are just revamped and modernized, it would be directing you to a link or the clerk's office or something that would, if we're just cleaning up a lot of stuff. I'm not opposed to what we're doing. I'm merely trying to get an idea of what I can brace myself for, because if we're doing it at this level of detail and there are no issues that have come up, then okay, my mind is going to be trained to, okay, let's just look at every word. But if we're really looking for,
I think it's a very legitimate question. I was proceeding as I thought we were supposed to proceed. Believe me, I have other things to do. Delighted not to do this. On the verge of not doing it anyway. I'm so exhausted from this. But I thought that's what they asked us to do.
that's fair, that's what the charter.
Maybe we should ask them a question, because I think it's a very legitimate question. We could be done pretty quickly here. Whether they really want us to go through this charter from the beginning to end and do it, and the truth is, Paul, you hate this, is that a lot of this would be done, like if you were doing it in one of your cities, a lot of this would be done at your desk. You'd be going through the charter, page by page by page, saying this should be for here, this should be for here. Wouldn't be done by a charter board. You'd be presenting, like Paul did in the beginning, this needs to be done, this needs to be done, this needs to be done, this needs to go out.
Do you agree with that?
Yeah, that's the way it would be, but a lot of it would be done at your desk or my desk, right? So I think it's a very legitimate question to ask, and I'm not wed to any particular way. Believe me, again, I have stuff to do. So if the commission doesn't want us to do this, if the commission really wants us to do this, I'll do it, but I'm happy not to do it.
Yeah.
Is that fair?
That's fair.
Okay, so let's ask them.
That I'd probably send it as a communication, ask you a question.
Go ahead.
I would probably suggest
That's what I'm
you send
saying.
it.
Same way that we asked them the other question.
Same way, or do you wanna do it with formality with a motion?
I think on this one,
Communication.
I think Anthony we get a feel for what they want us to do.
That kind of thing really can't be done, you can't go commissioner to commissioner.
No, I think it should be
Bring
done
up at a meeting and.
at a meeting and ask them the question.
Yeah.
Listen, nobody be happier than me and you.
Yeah. It's a huge commitment, and we're just, we're looking at section 8.
Right.
I don't know, and I know this charter is voluminous, and I'm thinking, okay, we going through each page. Well, it only goes up, I guess, the
Right.
section.
Something pretty small.
Yeah, okay,
No,
it's
but there's a whole
section 11.
human resources section, and a civil service section, and a section on everything that anybody ever wanted to put in a charter. There's all those sections. I'm happy not to.
Yeah, just a question, I mean, I don't wanna rock the boat.
No, there's no boat rocking. I'm rocking it with you. I'm happy. I'm rocking. I'm rocking getting done. Alright, so, just for the sake of completeness, I'd like to finish with Article 8.
Of course.
With Article 8. And then, we don't have much more, do we, of 8?
We have till December second.
Okay, let's go finish with 8, just for the sake of, we did Article 8.
Absolutely.
And then, at the end of that, we'll have a discussion as to what we wanna do for the remainder of the day tomorrow, okay?
Chair,
Yes,
so are we gonna ask the commission in a communication or
Yes.
in?
yes. I don't know what that means in communication, we're
Well,
gonna
we
ask
have to do a motion and we just have to state the.
Yeah, someone
communication.
states it on the record, make a motion, they'll vote.
Okay, well, I forgot the first one we were gonna ask him, what was that?
The first one you were going to ask was,
Like the question? What was the first one? We had one other question.
we did, hang on a second.
Okay.
And we should do it as a real motion, like
Yeah,
somebody
maybe
making a
you
motion, second, and, yeah.
Let's see if I can get back to the first question. Yeah, we had one dealing with.
Yeah.
Government, was it?
Yeah. Well, no, that
Election
one,
cycle, what was it?
you had moving the form of government to another meeting so the mayor can attend, list of vacant lands updated.
And that's not so much a motion really, but the mayor to, I mean, should we just ask if the mayor wants to attend, maybe
I
he's
know
gonna.
that he wants to.
Oh,
attend.
there, okay, well, there you go.
Yeah, well, there's one thing that you were specific to do. Gabrielle, okay, you have it?
I've got it here somewhere.
David, you have it? Yep.
I just kind of remember something about the strong mayor.
And the form of government,
Form of
Yeah.
government,
form of government and election cycles, that's what I have written down.
right question.
Well, the two things we
I
decided.
think I have it. I think I have it. P3, ask the question, what do you want for charter in light of the
Yeah,
proposed
that's
ordinance?
a-
That's
So here's our,
That was
okay,
me.
so I'm gonna
Why would
make
I-
a motion to ask the commission the following. Question 1. In light of the proposed ordinance dealing with P3 projects, would you like us to consider?
That was the sale of property.
But this was the one we were saying, we really didn't think any of that should be in the charter. And if our position is we don't think it should be in the charter, and that's a consensus, then we don't wanna ask them the question about the charter for P3, I don't think, you know.
Except that
It wasn't
has
clear.
us in there.
It wasn't clear.
Okay, well,
It might be clear to you.
But why don't- no,
it just doesn't make sense.
She's got a good idea. The question, you ask the question, okay?
Yeah, go ahead.
Okay, the question is, in light of the fact that the city commission is considering a comprehensive ordinance dealing with P3. The consensus of the charter review board is that this probably shouldn't be in the charter. Do you agree? Yes or no?
Perfect.
Okay, second question. The charter review board has completed a substantial amount of work dealing with what we view as as issues that have been raised by the public or by the commission to date. Is it your intention that we stop our work there, or is it your intention that we go through the charter word by word,
Reviewing every section.
reviewing every section to revise it and bring it up to date? Right? Okay, that's our, subject to editing by Anthony. Okay, that's my motion. Yes.
I'll second that motion.
All in favor?
Aye.
All opposed?
Dave, you got involved, that's good.
Yep.
Alright, so 8.10 Prospect Field, they're gonna come back to us. Same thing, 8.11. What about the shops in the Central District parking garage? I know what this is where that little store, it was right across from my office.
What is it?
Right,
Across from the library.
right in, east of the library.
Oh.
It's like a little thing that's never, no shop takes
Yeah.
Random country, savings, road shops, maybe negotiate by the city commission act this year.
So the city can lease shop space in downtown parking garage.
It's an exemption, special exemption for that. If they want us to go through, we will, but I don't see any reason to change it. Sort of getting that bird that bandwagon. Okay. Leases to civic and charitable organizations, have we? Does this covered in 8 the first one that we did, or was that just government?
That's just government, I believe. That's just government. What's interesting about this one is, what's interesting about this one is, well, I can read what I have, but I'll start with what's interesting is like organization. That's kind of amorphous. It would include, I forgot what they call it, public benefit corporations. There's a new category of corporations. I forgot what it's called exactly. Something like, I can look it up, but it's like public benefit corporations where there's a public benefit even though they're for profit. So my question has been, what does like organizations mean? So anyway, I'll start with what I have here. The city can lease property to civic organizations, charitable organizations, public nonprofit corporations, and like organizations for a period exceeding 1 year but not exceeding 50 years if it is consistent with the public good. The City Commission adopts a resolution declaring its intention to lease a definitely described property to a named civic or charitable organization, nonprofit, or rental right. A public hearing is held with notice published in the official newspaper, and that would be 2 publications, which is called a public hearing.
Where are you reading from? Where are you reading
I'm reading from something that.
He's reading his notes on 813.
Yeah, that we prepared.
Oh, okay.
Actually, this was Ashley Dussard, what's the title? Public information.
It's just,
Strategic communication.
Strategic communication.
She put together, and I reviewed it, and we kind of did it together. She put together a plain language compilation of Article 8. So that's kind of what I'm going for.
Okay.
So, a public hearing is held with notice published in the official newspaper. A referendum is held if 15% of registered voters file a referendum petition with the city clerk before the day fixed for the public hearing. So, there's a lot to this.
I'll set it back down, I'm with the Bernadette Bagway. Again, if they want us to look at this, I'll look at it, but nobody's brought one thing up about this, there's no question about this.
This is almost more complicated than like leasing it to,
I know.
another public entity.
You look at things in the light of what we just discussed, I mean, it's just so much.
Well, if these things are not an issue and they're not on anybody's radar,
So that's what we're asking, nobody,
Yeah.
they're not in, but that was I'm happy with that point of view, but, city commissions, county commissions from time to time do go through their charter and really update it and make sure that it's clear and just modernize it.
Yeah, and that's normally a direction to the city attorney's office, that they're bringing us something. But for us to sit here and wordsmith, that's a lot.
I mean, the airport itself, that's huge.
When there's no
That's
issue.
huge.
By the way, not to, if this was gonna be done, this is a massive
It is.
project to do. But I think you raised a very good point, which is if we're not addressing specific things that have been raised, then we need a draft to go through. Right, need a draft.
And if the commission takes the position, just what I'm sure if the commission takes the position that they want us to go through it, then I think also within that needs to be a direction to the city attorney's office to bring us something back to look at that,
I agree.
that's been thought through. It's not us saying, hey, talk to somebody in the city,
Anthony, I think we should add that to the communication, which is, and believe me, I'm not doing this, and she's not doing this, but if we, either of us, we're gonna be hired to do this, it would be 2 or 3 lawyers for a very long time.
That's right.
Going through this charter and charging a
A
big
lot of
fee,
money.
a lot of money to do this. I mean, seriously. And so the task that we're putting on the city attorney's office is not small. I mean, if I was doing this, or she was doing this, she'd have 2 associates here sitting with it, taking notes, going back, spending day, going through all of this stuff, and presenting us at the next meeting with a new draft of the charter.
Exactly, and maybe hire, and maybe, and no, but maybe you hire, cause maybe the city attorney wants to hire a consultant, another attorney to look at, I don't know,
Or
but I
municipal code
but I
corporation
just,
does
yes,
this.
something, but I'm sitting here thinking, this is way too much. I didn't sign up for this.
Have we not been talking about this for a while?
This is way too much.
Yeah.
I've been talking about this stuff for years.
Then how do we get the public involved? Because so often these things are done in a tunnel. And that the folks who get paid to do it get to do it, but the people who have to live by what it is that you all are paying to do it get no voice.
It still comes back to us.
But
It's still, we still get to review it. Public still gets to come in. It's gonna go to the commission. The public can come in again. We're gonna have community meetings. But what we're talking about, respectfully, is how do we get to a point where we have a good draft that's been cleaned up, that things that are in conflict have been looked at, and we're actually looking at a document that has been reviewed by attorneys, professionals who are doing this, not us sitting around with very limited information. We have more questions than answers. I don't think this is an efficient use of our time, but the public still gets to hear it. The public still gets to participate because it's still gonna come back and we're gonna have, go through all of the questions and ask things, and we're still gonna review it. It's just that,
absolutely,
it's just that.
I came in on a very short note. I haven't been here that long either. I've only been here maybe
But
a
you've
couple
had
of
a
months.
very good time.
Yes, absolutely. I'm gonna make sure I have that. But on top of that, but what I found out, or what I believe is at the table, are issues that the city commission wants things to be narrowed out, like the land.
Yeah.
Land has been a very important issue, and one that the public has been screaming for a while to address. So I was thinking that was at the table between what is leasing, what is licensing. The other issue at the table was dealing with elections, where folks been screaming and hollering for I don't know how many years now for them to address those issues. So what I've been dealing with only in my short period of time have been those issues. And I would agree with you, this is a lot without a paycheck. However, I'm the questions that are going to be asked, I just think it's important to just keep in mind that the public's voice needs to be a part of whatever we are going to be doing
The only thing I
as a
would add to
long-term
what
option.
Bernadette said is that I think that the public out of the public input portion of this, we could get other things that come back to us, which we could say, okay, people are raising
Yes,
questions
right.
about this or that.
Now let's look
So
at
I
that.
think that I think that's what you're saying.
Right.
So I think that the public outreach should still be available, like, how do you think the city is working with government, blah, blah, and stuff could come back to us, and I think that we can address it, because we're no longer shadow boxing.
Yeah.
We're having somebody raise an issue, but it's the question of addressing things that so I think
Nobody's
that
talking about,
answers your
yeah.
question, which is, you can't just have this done internally by a bunch of, professional people, there needs to be some input from the public before they complete their work.
And I agree with you, and I'm assuming that's going to happen anyway, right? Like the commission, they're gonna give us some direction, they're gonna have maybe other issues, we'll look at those issues specifically. But the things like we're going through now, where nobody's raised any question about, there's been no discussion about in 50 years, you know, I just don't know that it's a good use of our time to go through that kind of stuff. So that's more or less what I'm talking about.
Yeah, and I think it is a lot, but in the same voice, I think the voices of the people have to be a part of the participatory process.
And it will be.
All right, so I'm really very comfortable with what we're talking about. I think it's very helpful. I really appreciate your raising it in this particular way because you were able to step back because you're just stepping into it. The question then is, should we wait before we spend a lot more time doing this kind of grinding through stuff until we hear back from them? Or should we just keep, I'm inclined to basically get the questions asked and say, you know, even though, yeah.
Chair, can you articulate that last part that Ms. Norris Weeks said so we can put it in a communication, add that part? It needs to be in the motion.
I thought I did.
I think what she's referring to is, should the commission determine that they want us to grind into every section, then what I'm suggesting is that the city attorney provide to us a draft to complete that work. Like, I don't mind doing that work, and if that's the will of the commission, but we need it more cleaned up than what we're looking at right now.
Just wanted to get that clear on the record.
That's exactly correct.
May I say something though? On the other hand, though, in order to do that, I mean, it kind of goes both ways because I would need some kind of direction. What am I looking for? What am I
Right.
saying?
So for issues that, like we've talked about so far, that you know are on the table and we'd like to see changed, you're gonna go back and you're gonna look at, like when we picked up some things looking at this, there were some clear inconsistencies, right? Because we've already talked about things we'd like to see and we took certain votes. So to go through the rest of the code, looking at it from that standpoint, in addition to things that you know are inconsistent with whatever, talking with management to determine what's operationally inefficient, or you know, all of that. I think you meet with management, you bring back some recommendations as to what.
Let me give you an example, Paul. Like section 811, sale of real property for Lauderdale Executive Airport. What we're suggesting is they go speak to the airport staff and you find out, have there been any problems leasing property? Do you use this provision in order to lease property? Is it working for you? Does it need to be changed, or is it fine the way it is? If it needs to be changed, you propose a change and say, airport staff has recommended the change. If not, I've spoken with airport staff and they're fine. That on every single section. The human resources section, civil service, you speak to human resources. This is what it is. Is it fine? Does it work fine? What sections need to be changed? This conflicts with collective bargaining agreements. This is outdated because of federal law, blah, 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 and all that. And we need, and she's right. How did I not see this before?
And then bring it back.
I don't think we ever got this far before.
We will just sit here
That's
and
why.
we will keep asking you questions that you'll have to go back and bring back 50 answers, and then we gotta review it 5 more times. I mean, it just doesn't make any, this is not efficient.
Well, just by way of explanation, this is how it's been done since I've been involved with this board for 20 plus years. That's how it's been done. That's just how it's been
It's
done.
no way to run an airline.
It's just how it's been done.
And that's why, honestly, why this has been going, you know,
Right. You go over sections.
It's called what, insanity?
You give me some direction, I come back to the next meeting with a rewrite, and then we discuss it. And that's how it's been operating.
And you know what, honestly, for sections that people have raised, I think that works very well.
Yeah.
For the sections that we've dealt with, but we're done.
We have never gotten this far, and if I recall,
Yeah.
prior to this board, the other board, there would be like 3 meetings on just, where does the city manager
Yeah, you're right.
really want to tear my
But
hair out.
there are still some, as a result of today's meeting, that follows that model, that I need to go back and
Right.
redraft,
Right.
redraft and come back. there are some sections that are still like that.
That's fine.
And maybe this would have been fine for a 12-page document, which most charters are, not including the legal description. But for this is, no.
Well, we are over 100 years old, you know.
Okay,
A lot's happened.
so, okay, in the interest of time, is there anything else that we, and this is David, Junia, Anthony, Otter, yes?
The only thing I'm trying to go back in history, but when it first started, at one time, wasn't there like 2 letters that said, like, these are the exact sections that they wanted to start with? No?
Yes.
Yes,
Yes,
okay,
we did, we went through them.
okay, cause that's what I thought was,
Not letters, there was a letter, there was a memo from the city attorney's office that we've gone through.
okay,
There was a letter, there was an email or something from Alan Ballou, were sections that he wanted us to go through, same thing. And then there have been some comments from the city commission saying we wanted you to do this, and we've gone through those things.
Right.
So, and then we've had issues from the public that were brought up by the prior board, we've gone through those things. Elections, those kind of things. And the other ones, which are big issues, form of government, staggered term, we've said that those things we need to get input from the public to see whether they think we need to change or not. So, if it's all right with you, I think, Anthony, we should do more of an interim report. Like, this is what we've done. These are issues that we think we need input from the public on, in addition to whatever else they wanna talk about. And then we have these questions, and if you want us to do the whole thing, this is what we think, this is what you need to do.
It's basically that memo.
Do you also want to present the sections that you have resolved?
Right now, I want to get some direction from them. Cause I don't wanna give them, they've asked us not to give them too much at one time. So if we just give them a sort of a status memo, and I could, in the memo could say, or would you just like us to stop at the moment and give us what we've got?
And you guys have voted on some things already, so
Yes.
why not take up the things that you
Yeah.
voted on so they can
We've
start
gone-
digesting that?
We've gone through everything that we voted on with you.
Oh,
We went
well,
through it
good.
today, we redid it today.
Take a
So
bow.
What?
that,
I said take a bow.
Oh,
Yeah, no, but I mean, you're up to date on everything that we've voted on.
Perfect.
Anthony, what, do you have a comment? What do you think about this?
No, I think it's fine. I think as long as the communication is clear, they can have a hard time responding sometimes if they're not certain, but I think
Yeah,
you're
but
being
we'll
pretty
write it
clear.
very clear, I'll
Yeah.
have, if it's all right with you, I know what everybody wants. I'll work with Anthony, we'll do a clear communication, as you guys know, I have no agenda here. I'm happy to do whatever.
and
Richard, I want to refer back to a word that was used here on 8.13, like organizations, what is that?
We don't know, and we don't know if it's a problem.
It is,
No, what I'm saying is if we're gonna start going through all these sections, then I'm gonna get rid of those words, cause I don't know what they mean.
right,
But if that's not our job, then I'm gonna leave it alone.
Yeah, and then in terms of the, on the agenda, you said sometimes it takes a while. I think if the city manager put an item on there, either under her report or some other place that's appropriate, that allows for them to have the discussion and it's on the agenda, then they're gonna have the discussion. But if
Don't we
it's,
put these
if,
items on the discussion, I don't know how it
They
works.
go on the agenda under communications and then that's where the discussion tends to happen.
that'd be, the sooner that can happen, probably the better.
It can happen at the next meeting, at the August meeting.
August,
right, the next meeting is August 19th.
So listen,
If that can happen.
whatever it is, because again, they asked us to get some stuff on the ballot this time. So,
and we have until next year, so.
yeah, but when do we have this?
Yeah, but the dates, yeah.
I can pull it up, let me see.
Hey,
Yeah, generally,
let's not worry about it.
yeah,
I think it was
generally,
June or
the
something like
supervisor
that.
election side of this, they don't need the ballot language until like, you know,
I think it's June.
June, early July,
We have
if you
like
can,
eight-
yeah, you
Okay,
can
so we
actually
have
push it.
time to get everything together, to make a recommendation, and if that's what they want, give it to them and they have time to consider it. Correct.
Chair, is the intent for August to communicate a message to the commission, or is it to present some findings, some outcomes, and
No,
seek
just the
direction?
communication to get some direction from the commission.
but we can say what we have approved and what sections
Yeah, we're
we've
gonna go
approved.
through the sections that we've approved. We could include them if we want.
Yeah, I've got a running list
Okay,
in that
I think we
draft memo.
should.
Yeah.
Yeah, I think
So
we
it's
should.
section.
We'll do another report, hopefully it'll be better received than last time.
Well, because it won't be so much, and also, I mean, if we can include what we've approved, it's just like, this is what we've approved, we don't really, expect you to vote or anything on it, but let's have some discussion.
Yeah.
Probably like a
Yeah, the
conference
way I have it
meeting,
drafted is just, this is the update.
Yeah.
This will be brought back as a consolidated package for ultimate direction.
And that way, we're not like slamming them with a bunch of stuff at the
Yeah.
close stuff.
Judy,
Two things, and Anthony, would this not be too much with the memo that's pending for the commission with the community outreach piece? And this communication for the commission?
Well, there's two things going on really, I think.
Right.
We've got a memo that we're drafting to kind of keep them updated on what's happening month to month. That we
Okay.
still haven't yet to send the first one out. And then there's the formal communication that they voted on to send to them. So we can include that communication in the memo, but that's gonna be an item on the agenda that's separate anyway.
Okay, so that the memo wouldn't be a communication.
Well, it is a communication, but not in the sense of
Not
they
in the-
voted and, you know,
Okay.
there's multiple ways.
what we're doing is gonna have to be asking questions, all right?
Yeah.
They're gonna answer.
Right, I think what Janine was trying to impart is that if we're just doing it via the memo, it's gonna be this big, long, lengthy thing, but you're kind of breaking it up. You've got the communication that you're asking the question that you want direct feedback on.
Yeah.
The rest of the memo is gonna
It's
provide
an update.
details and updates on what you've been talking about and where you are in that process.
Okay.
So I think both are fine. I don't know, Ben, if you got any strong.
I just wanted to get clarification if there's gonna be a formal presentation and like backup material, because typically we wouldn't do that as a communication. We do it as a conference agenda item, so that way the materials are published, people can see it in advance. And if you're talking to things, it's on the screen. Usually communication is just a letter that is.
Right, so I anticipate that to happen once you get the response from them and you know what your next steps are. So you're asking the question, do you want us to go through it soup to nuts, or are you okay with what we've done, and do we stop? So if they say you want it soup to nuts, then there's more work to be done, and then once you're all done, we compile it all, it's a joint workshop, we present that to the.
But I think what Mary was suggesting was that in terms of what our report to them, that we give them information about what we've done.
Yeah, absolutely. I'm trying to address what Ben's saying, that typically if it's gonna be a presentation, it'd be backup material, presentation to formalize whatever. I see that as a joint workshop when we get to that stage. We're not at that stage yet.
Anthony, what will allow them to just simply consider the questions that are posed by this board?
You've done it.
Okay,
You've done it.
All right.
You made a motion.
Okay.
You verbalized what you want to ask the question on. I'll work with Richard and David on what that final language actually looks like.
so, and then with an attachment to that, this is what we've done,
Yes.
by the way. By the way, this is what we've done.
So for the communication, Richard said the two questions that are to be asked, and then as Norris Weeks, you added a little additional to it. Do you wanna leave, or do you wanna put that as part of the communication, or when the communication comes up, somebody at the meeting kinda just?
No, it's gotta be part of the communication.
Okay,
If
so-
they want us to do soup to nuts, then this is what we suggest.
Okay, so
Paul, at the risk of adding complications though, there are sections that you've asked me to go back and rework. So those are not while they may have been approved previously, they're not necessarily your final work, so I'm not sure if those sections should be in that
We should not be in the communication until this board is approved. But that
Some of them
doesn't
were
mean,
big.
and what?
Some of them were big ones.
Yeah, we're gonna have to go, you know, we can tell them we have other ones that are sort of
Pending,
just about
pending.
done. Anthony, we need to say also in the memo that we have some sections that we agreed in concept that are currently being drafted. That's a different group.
Gotcha.
And if you have those already and you know what those are, maybe you give them the preview of, to include sections.
Well, they're not quite.
Section,
Yeah.
X,
Just a list of them.
you know.
We can just do a list of
Just
the
the
ones that,
thought,
I don't wanna give you the language until.
No, not the language, just
the
just to include sections, this, that, and the other.
Yeah. The way I've broken it down is I provided everything that was on that agenda, and then I pull out the ones that you went ahead and voted on, so I can just have another category that talks about that.
Alright, Judy, did you have something?
Yes, just keep in mind, I'm probably getting ahead of myself here, your next meeting is August 7th, so you can discuss if you want to have a meeting August 7th. The commission meeting is August 19th, or if you want to wait till August 19th.
We do have language that's coming back
I think
from
we
Paul.
should have a meeting on August seventh to go over
Okay.
the language. The thing should be on the agenda is, number one, do we want to have is the mayor gonna be back in town?
August seventh?
Yeah.
Should be.
All right, I just wanted, he wanted to come to us and I'd like to
To talk about the strong
courtesy
mayor
of
issue.
talk to us about the strong mayor issue. Given also that we're gonna go out to the public on it too. And then just follow-ups on these items, on the drafting items, not be it. And then a report, the most important is gonna be a report from Anthony and Junior as to what the city commission told us.
It'd probably be helpful for that communication if a member of the board was appointed to be there and could speak.
Okay, well, we got really nailed, I got nailed on this twice.
I'll go with you, I'll go with you.
No, I got nailed twice. On the city attorney report,
Oh, yeah.
you know, that, you know, I got nailed because nobody asked me to be there. And then somebody said, well, why isn't somebody here from the city attorney committee? Nobody asked. And then the same thing happened in the charter
right.
committee. Why isn't somebody here?
Well, that was a walk-on also.
Yeah,
That was
that was-
very unfair.
It doesn't. Anyway, not that I particularly care, but it's, if they want us to be there, fine.
I cared.
When is it?
I was not
August
happy.
19th. And typically for.
No, the next meeting, this is gonna be presented to them this week, right?
No, August
No.
19th.
You're on vacation,
They're on
August
vacation.
19th, that's why I mentioned that,
Okay.
that's
so-
why I mentioned, cause your next meeting is before they meet.
Oh,
Yeah.
all right.
So which
They're
is
on
good.
vacation now.
That's good.
So maybe the next meeting can consist of the mayor coming if he
And then
wants to
wrap up.
come. And then for the language that you've been working on, to bring that back to
Right,
us.
and then, but we won't have answers from the city
Right.
commission then.
Right,
No,
right,
but we need to get
at
the
least we're
wheels,
showing
yeah.
that we're
Moving on.
Yeah.
Okay, and if it's August 19th, somebody else needs to go, because I'm happy to adjust my travel to be here on August for
Yeah,
our
it's just
meeting.
sometimes they ask if someone's in the audience.
That's
to speak to
fine. So,
August 7th.
you wanna go?
So are we moving to cancel for tomorrow?
We are.
The motion on the table?
You look very excited.
Oh, second that motion.
I don't know that I'm smart enough to be the person, appoint the person. I will be there, but I,
Okay, so what do we want? Okay,
Yes.
I mean,
I'm not gonna worry about it right now, but I have it on my
Well-
calendar. I will go.
I will decide
at
when we
the
meet
August.
next, who should be there.
Are you still gone in
You
August?
would be great, you would be great. New vice chair.
David?
You come hold my hand.
That normally when a communication comes up, one person can speak, we can notice it on the agenda that two or more board members may be in attendance
That's a good
or
idea.
to speak on it, so if more than one person wants to speak. We've done that with a few communications and
I mean, I'd
items
be
in the
happy to
past.
be there, it's just like,
And you don't really even have to, it's a public meeting, so.
There would need to be a notice at least of two more members of this board,
Correct, yes, that-
not just putting it in the city commission agenda. There have to be a notice of this board.
that's correct.
Can I, have a question though? Do you anticipate refining your communication to the city commission at your next meeting in August? And we'll have those other
You can.
sections?
we will have, Anthony and I will have a draft for you at our August 7th meeting.
Okay.
So you guys can look at what we're telling them and we can refine it, tweak it, and then we'll send it, so we won't send it until after we meet.
And if you get it done early, feel free to send it to us.
We will.
And does that meet agenda deadlines, will that work?
August 7th.
August 7th to the 19th,
August
should be
7th,
fine.
we should, yeah, that's more than 2 weeks.
So we would be publishing most likely the 13th or 14th, so
Yeah,
we should be able to turn around the
yeah, because it's 2 weeks in between.
So, Mr. Chair. Richard did, Nadine, thank you. Made the motion that tomorrow's business is adjourned.
Or we're meeting for lunch. Yes, I think we should, do you, yeah, is there any reason why we should not?
There's,
We should not have a meeting, I mean, I feel like we've
Post the
really
notice.
come to a good point here, right? Okay, so thank you everybody for organizing this, especially Junia, thank you so much.
Junia, thank you.
Paul, Gabrielle, thank you for getting such a good job on the agenda. And that's it, we're adjourned.